If this
Namaste, everybody in South Africa. That is a traditional Indian greeting. Hi there to all from Udaipur in Rajasthan in India.
Right? I don't think Robin will in any way mind if it is that over here where she can see. So hopefully you'll be able to do that. I would like to introduce also some of the other speakers of here, Nopinki. Where's Nopinki now? Oh, there she is. Ms. Nopinki Jingalizi. She will do a presentation later on regarding the app that they developed. So thank you for coming today. Anneke, thank you for being over here. Anneke Guyvenstein, also a regular client and also Beerman of Mr. Zimmerman and Robin Zimmerman, Beervrouw of Zimmerman. That's how I saw they are on WhatsApp. So that's why I'm calling them Beerman. Then also we have Liesel Cornier. And I just quickly want to, I know I'm taking a little bit of time, but I need to say this. Over the years, we have had women sitting in the corridors of the maintenance courts, not talking to one another, everyone just over there for their own thing. Ms. Cornier started this thing where she goes to different courts and she assists women out of her own free will, despite her own case that she's struggling with. And on our WhatsApp group, we've got 300 women on our WhatsApp group. She sends a message in the morning and telling them, I'm going to Belleville Court. If there's anyone that needs assistance, I'm there. And then Ms. Liesel Cornier is the one that goes and assists people. So if any of you have a case in Belleville Court, or even if you have a case in Mitchell's Plain, she started a Mitchell's Plain group too with another, I don't know how many hundred women and people in that group that she also facilitate, except the Somerset West WhatsApp group that we had. It's not called the Somerset West group anymore. It's called the maintenance support group that's also being headed by Liesel Cornier as well as Arnel Russ. Can you quickly stand? Ms. Arnel Russ, they are the people that are quite active on our WhatsApp group to inform people of the communities of what they need to do and how they need to get assistance. So if any of you need assistance, please speak to them. It's not just me that have all the knowledge. There's a wealth of information in this room, and it is time that we start tapping into those type of services that we have available. While we are here, we're going to have a tea break later on around 10:11. Please support the cafeteria owner. He came in especially because I asked him to come in. But at the end of the day, it must be worth the while for him to be wasting his whole Saturday to have meals available, to have coffee available, 10 rand, scones available. I sound like an advertisement agency, 9 rand for scones. And there are some chicken sausage for 70 rand, or chicken sausage, lamb and salad, and bread for and lamb for 100 rand. So if any of you would like to then participate and support our cafeteria, please do so. I will really appreciate it. In just to say, in lieu for all what we are doing, making this home available and having all these facilities available, the handouts, the lanyards, and all the things that we are providing to you. If you can make a donation by supporting our cafeteria, I will really appreciate that. The online people, if there are some of the online viewers that would like to sponsor a meal to any of the people in the room, you can do so by WhatsApping um, Fabian Daniels. His details is on page 2 of the handout that I sent last night to all the online viewers. So if any of you would like to send a WhatsApp, you can order your meal now, so you don't have to stand in a long queue. So if you want to make sure that you order your meal now, what you can quickly run. You don't have to wait in the long queue when it comes to it. But the online viewers, a special appeal. If there are any of you that would like to get the handout, we will make the handout available after the session. The session is being recorded on StreamYard, on YouTube, and on Facebook. If you go on Facebook, then just search for NPA Community Dialogue, and you will get to the NPA Community Dialogue and will be able to view it live on there. If you don't believe me, just do it now. Go on Facebook and then see if I am live. There might be a few seconds lagging, but you will be able to hear me clearly over there. My wife makes sure all of these things over here in my face. It is to make sure that the online viewers can hear properly on the other side. So Facebook, NPA Community Dialogue, Instagram, NPA Community Dialogue, and on www.childmaintenance.org.za, there's also a live link, so you can go on any of it. Any of the old videos that you want to watch since January of this year, you will find on a YouTube channel with the same name, NPA Community Dialogue. You will find all the old videos that we have been talking about maintenance since the beginning of the year. Mr. Eugene Opperman is in India right now, but he is also viewing the live feed to see if we are doing the right thing over here. He's the techno guy, so he's checking out if all of us are doing the proper things from India. He will later on give a special message all the way from India that he already sent me. He said, send it still so long for us, ek wil nie sukkel nie. So he luckily sent it to me. So I'll play that a little bit later on for all of us to hear, where he is in India busy with his 16 days of activism contributions, as well as making sure that the Indian community also know about the NPA community dialogues and what we are doing in South Africa. Felicity is in Limpopo. She is busy. Felicity Guest, she's got a Facebook called Child Maintenance Difficulties in South Africa. And she's in Limpopo for a conference where she is also addressing the people up north and making sure that they also get the information that we are having over here. So any of the information on YouTube, NPA Community Dialogue, you'll find all of it over there. Okay, to start off our program, we're going to ask Mr. Quentin Zimmerman to come and speak about the National Credit Act and the specific link to maintenance. I've never understood, or I just thought I need to focus on my Maintenance Act and the maintenance regulations, and I know everything, until I heard Mr. Quentin Zimmerman speak at the Institute for Social Justice's summit that we had last month in Cape Town in Durbanville. And stunning. I've heard this man speak, and I said to him, "You must just come and do it." Sorry, Anneke, we are poaching everyone that was at social justice. We are bringing all of them. We had Mr. Derek Beekers over here last month, and this month we have got Mr. Quentin Zimmerman. His beautiful wife behind him is Robin Zimmerman. We will hear her sometime in future too. So we're going to make it a family affair. Her daughter or their daughter next to offered what can she do in order to also contribute to the NPA community dialogues. And she started this morning by offering the tea and coffee. And she asked if there's anything else that she can assist. So if there are any volunteers that want to assist, we always need somebody to assist, even if it is just allocating a parking bay or helping with some more parenting to be done or assisting in the cafeteria. Please help us. This is what community is all about. Community is where we help one another. And it's not about I'm sitting there and I'm in my own space. I don't want anyone to feel that way. I want you to feel included in this process. And if you do not have sufficient funds for a meal, please let us know. We will find a way to somehow make it worth the while for you to be here, in order for you to also benefit from the information that we share, as well as what we want to do. Please stay after the event and socialize with us and learn from us. There are more copies that I made for those that want to take some copies back home or want to share with their neighbors or whatever the case might be. Please take an extra copy, take it to your church event tomorrow and give it to somebody that might need that information. Tell them about the NPA community dialogues. On the last page of the NPA, of the handout, is a program that we are planning for next year. Our first NPA dialogue for 2023 will be on Saturday, 28 January 2023. So we will then start, and we will get a sign language interpreter. The Deaf SA already said that they would like to get involved, and we'll have a sign language interpreter sitting next year, and we will stream it online. And the Legal Aid Board, Dr. Kotze and her team up north in how that need sign language, we will be providing for them from 28th January 2023. Our regional lead, Mr. Rodney Isaacs, also wanted to be here, but unfortunately he had commitments in the Northern Cape. The regional lead for the Department of Justice is Mr. Rodney Isaacs. He would have been over here today, but he will join Natalie and I in George. Next week we will be facilitating training, the last training for maintenance clerks in George. Be it as it may, Mr. Rodney Isaacs will be over here as from next year, and then you will meet who's the regional head for the Department of Justice. Also, my other colleagues in the NPA will also join us next year. In the month of August, we met the NPA Western Cape director. Her name is Advocate Nicolette Bell. Nicolette Bell will also be joining us now and then and bring her team of senior advocates. My boss, Advocate Lizelle Africa, will pop in every now and then. She was here last month and the month before, but she will, as from January, the whole soccer team, that's the Sexual Offences and Community Affairs Unit of the NPA, will also be joining and be presenting on domestic violence, on human trafficking, on sexual offences, the GBV legislation. We will go to it step by step. Everyone will know what to do and what to expect in the system and how the policy work with it. What is the Department of Justice supposed to do? What is the NPA supposed to do? What is the police supposed to do whenever they are dealing with these type of cases? So we've got a beautiful program for next year, exciting program. I hope you'll be able to join us, but let's see what happens today, and then you decide whether you want to be part of this event and of this dialogues, and then we take it from there. So without any further ado, Mr. Quentin Zimmerman saying, "Wanneer gaat die jong klaar praat?" So let me finish and give you an opportunity. Over to my brother and friend, Mr. Quentin Zimmerman.
Thanks, Leon. Okay. Just give me a second. Okay.
Sorry. My slides have 4 on one page. Is there another one?
Just go for
You can choose now.
Okay, you'll sort it out. Okay, cool. My name's Quentin Zimmerman. I'm an attorney. I litigate in the Magistrates Court in the High Court. I also litigate in the the National Consumer Tribunal as well. I litigate mainly on National Credit Act issues. That's to deal with credit agreements when banks are suing in terms of homes, cars, credit cards, any sort of debt-related matters is where I get involved. And then I was asked to give a presentation at another summit in terms of how that piece of legislation in terms of the National Credit Act can help in terms of maintenance. And on the face of it, one would think, well, I mean, maintenance is dealing with issues between two parties in terms of arrear maintenance, children's maintenance. And then you also have the National Credit Act, which regulates the relationship between credit providers and consumers, and they're completely different. But if one looks at it and one actually does an analysis of it, we can see some practical applications of what we can do in terms of the maintenance field to assist people out there in terms of being able to execute on their maintenance orders and be able to make it also sustainable and reasonable over a period of time. And there are a lot of mechanisms available in terms of what we can do in the maintenance field, which also has application with regard to the National Credit Act. And that's what I'm going to be here to do today. I'm going to go through the slides. In the slides, I'm going to list all the sections of the Act and the regulations that I'm going to be dealing with. I'm not going to read through all of it. We're not all of you are attorneys, and it'll be very, very boring, and I don't want it to be boring at all. So the law is going to be there, but I'm rather going to discuss what it's about and what it means in practice, because I think that's what's important. It's all good and well that we know in terms of this section, we have this and we have that, but what does it mean in practice? What can we go and do when you go to court and you want to argue a matter? How can that help you take it further? I've also provided the slides to Dion as well. I think there's some printing issue with some of the slides, so you can always ask Dion. You can also ask me as well to email you this stuff. So everything I'm going to talk about, all the legislation that I'm going to be referencing, all the relevant sections will be quoted. You'll have all of that in front of you. You can ask for it as well as a PDF as well. All right. I think it's jumped one slide ahead. Okay, the next slide, please. Okay. One of the things we need to first take into account is what is the status, what is the legal authority of the maintenance court when it makes an order. In terms of Section 24(2), it specifically states an order by a maintenance court is the same as a civil judgment. But as I'm going to be dealing with later, you're going to see that maintenance seems to be treated differently. It's not treated as prominently as it should be in the enforcement of when it comes to debt. So when it comes to debt obligation, when it comes to maintenance, there are two separate things, but they should be dealt with in the same way, particularly when it comes to the extension of credit, the granting of credit, and what the implications are in terms of when one has a maintenance order in place and how one can go about enforcing that in practice as well. Next slide. There were some amendments made to the Maintenance Act, and in particular, I'm going to dealing with one that's very, very important and what's relevant to everything I've got to say today, and that is that when there is a default in terms of the maintenance order not being satisfied, and a period of 10 days has now passed, you can go back to the maintenance court and advise the court, listen, 10 days have passed, the other person hasn't paid their maintenance, and you can bring an application in terms of that. Now, when that application for default maintenance has been granted, what's supposed to happen in terms of the Maintenance Act, it's supposed to go to the maintenance officer, who then sends it through to the credit bureaus, who's the credit scoring of the consumer, and it gets supposed to be listed there. So in other words, when there's a maintenance order and there's a default in terms of the maintenance order, the legislation is in place that when there's a default, it's supposed to be listed on that person's credit profile. And we're going to see how significant that can be down the line in terms of the practical application of when that other person that's not defaulted on their maintenance, what happens when they then want to go apply for further credit? Because this is the concern many people have, is that you have someone that's not paying their maintenance, but then they're going and buying a new bucky, trying to buy credit cards and going crazy during Christmas, and then they don't have the money in order to pay their maintenance. So it's important that we have to give recognition to the changes that have been made to the Maintenance Act. But unfortunately, as it currently stands, even though we have the law in place, we do have a bit of an impasse in terms of how it's going to be practically applied. But the law is in place, and there are certain things that you can do out of your own in terms of it as well, which is why I'm also here, and I want to show you what rights you do have in terms of maintenance and in terms of credit being extended. Another important thing is there are obviously offences related to a person that's not paying the maintenance. Again, it's all in the legislation, but is it really helping in practice? One of the ways that it can definitely help in practice is in terms of Section 31(4) of the Maintenance Act. And this was amended where previously had the word the maintenance officer may, in terms of which he may refer the matter and that information of the person that's defaulted to the credit bureaus for it to be listed. That has been changed in terms of the amendment from may to shall, which means he has to. So it's more imperative language. To may is a discretionary situation in terms of the maintenance officer, but now in the wording being changed to shall, it now means there's actually an obligation placed on all maintenance officers that when there's an order in place in terms of a defaulting maintenance payer, he's supposed to send that information onto the credit bureaus so that that can be listed, which has obviously a massive impact on that other person's credit profile going forward. The next slide. So in terms of maintenance, one also then has to look at what it means in terms of when one applies for credit and what protections are in place in terms of the banks as well as in terms of the consumer that is applying for credit. And in this regard, I'm going to be first looking at the National Credit Act regulations, and then I'm going to be looking at the National Credit Act in itself. Now, in terms of necessary expenses, this is one of the requirements that any bank that wants to grant credit, they have to look at not only at your income, they've also got to verify your necessary expenses as well in order to make a determination of whether the person can afford the credit or not. And in the definition of necessary expenses in the regulations, it specifically states including maintenance payments. So a bank is obliged in law, before they extend credit to anyone, they have to verify and establish whether that person has any maintenance payment obligations existing as well in terms of if they are behind. And obviously, if they do, that will have a factor in terms of calculating what their affordability is. And if they are behind in terms of paying their maintenance, then that would be a massive red mark in terms of not granting that credit, because if you can't meet your current existing obligations, then how are you going to meet your future obligations in terms of the new credit that you're applying for? And that's what we're going to be dealing with a little bit more further as well. So we can also see in Regulation 2312, as I said, any credit provider has to take into account the maintenance obligations as well in any sort of assessment that they do. Next slide. Now, earlier when I first started, I mentioned that a maintenance order is the same as a civil judgment, but it's not being treated the same. But in terms of the regulations of the National Credit Act, it even actually goes further. An ordinary civil judgment, sounding money, you get sued for money to the bank, whatever, that can be retained on the credit bureau report for a period of 5 years or until it's rescinded. Interestingly enough, any order in terms of maintenance, in terms of the Maintenance Act, doesn't come off the credit bureau reports after 5 years. It actually stays there. It stays on the report until that judgment has been rescinded or until the obligations have been met and the minor children are now adults and they don't require maintenance anymore. So in terms of the law, a maintenance order, even though it's at the moment practically being treated as less than, in terms of the regulations of the National Credit Act, it should actually be treated more than a civil judgment in terms of the consideration and the effect that it has on a person's credit profile. Next slide. What the National Credit Regulations also introduced, and in terms of the assessment of affordability, is that there is a declaration that the consumer applying for credit must complete. And in that declaration, it is now a requirement in law that all credit providers must make sure that they ask this particular question before they grant the credit. And it especially provides for in 3.7 under maintenance expenses, payments provided by court order, and then that has to be completed. And so that's, again, fantastic. But now the question one would have to ask is, what happens when you have someone that's applying for like I said, a new bakkie? They go to the credit provider and then they apply for the credit, but they don't disclose to that creditor that they actually have the maintenance obligation. Are there any implications for that? And that's what we're going to be getting to shortly. And that's the crux of why I'm here today, to show what changes need to happen to make maintenance orders more enforceable in a practical way, that one can obtain and enforce those orders and ensure compliance of those orders going forward. In terms of Section 82, the next slide. In terms of Section 82, the assessment mechanisms and procedures, I'm going now directly to the National Credit Act. And those are, in terms of Section 82, it sets out what the credit provider must do in terms of doing its assessment, its affordability assessment, and it has to do it in a fair and objective way. Next slide. And this is where we're going to get to the whole ball of yarn when it comes to reckless credit, and the exciting part of why I'm here today, in terms of what does it mean. All this discussion about assessments, it's supposed to be listed. What does it actually mean in practice? What it means in practice is that there is an obligation on all credit providers that they need to prevent the granting of credit in a way that is reckless. They have to ensure that the person that's applying for the credit has a general understanding and appreciation of the risks and obligation, the cost of what they're entering into. They have to take in consideration the debt repayment history of the consumer. That's the credit bureau reports, which shows exactly what debt they have. Are they up to date with their payments? It usually goes back 24 to 36 months. And then also obviously taking into account the existing financial means, prospects, and obligations. So when you apply for credit, the bank's always going to ask for your ID because they've got to FICA you, proof of residence. They're going to ask for your pay slip. They're going to ask for 3-month bank statements. If you're self-employed, they're going to ask for 6-month bank statements. So irrespective of what you disclose to the bank, there's still a duty on the bank to verify the information that you're giving. So you can't just say, oh, I'm self-employed and I'm earning 100,000 Rand per month. Your bank statements that you provide to the bank need to show that that's actually the truth. So the bank can't just solely rely on information they're getting from the consumer. They have to be able to verify that in terms of documentary evidence. Very much the same way that a maintenance court will do when a person says, I can't afford my maintenance, or asking for a maintenance increase. The court has to interrogate the financial circumstances of both the parties in that regard. And in order to do so, you don't just solely rely upon what's the testimony that's been given at the court. One has to base that upon evidence, documentary evidence, because bank statements don't lie, pay slips don't lie. And that is a much fairer and equitable way of ensuring that we have the full facts and the full information in order to be able to make an order that is sustainable in the future in terms of its enforcement. Now, the issue that we have with regard to what does it mean if credit has been recklessly granted. And again, this is where it gets extremely, extremely serious for credit providers, and it can be a great boon in terms of any person that's trying to enforce the maintenance orders. What it says is that if a court finds that a credit agreement was entered into recklessly, it can do one of 3 things. It can set aside the entire debt. So that person should never have gotten that Isuzu bakkie. He could never have afforded it. The court can make an order. You know what? You hand that Isuzu bakkie back, the debt gets written off its entirety, and then that 4,000, 5,000, 6,000 Rand per month becomes now available in terms of maintenance, because it increases the affordability of the other person if you're able to write off the debt that they've entered into recklessly without giving consideration to the maintenance that is due and payable in terms of an order of court. The other part it can also do is it can also set aside part of the obligations. Generally, what we're speaking about there is a court can say, listen, the debt has been granted. It's not fair that the debt must be written off because the person received the benefit of the debt, but the court can then make an order, you know what? We're going to have the debt be repaid, but it's going to be repaid back at a 0% interest rate. So setting aside part of the obligation being the interest that's being chargeable, because the court could say we don't want the credit provider to benefit unlawfully from the reckless credit they granted, but they need to be repaid. So that would be in terms of interest being reduced. That also would obviously have a massive impact in terms of maintenance, because one of the biggest aspects when the court is busy looking at it, you've got to look at what the other obligations are. And if you can get the entirety of the interest written off and everything that's being paid towards that debt is going solely towards the capital that was loaned at the time, that'll have a massive improvement on that person's financial circumstances and the ability to pay maintenance or the ability to pay more maintenance. The other thing that the court can also do is also suspend the enforcement of the credit agreement. In other words, it doesn't get paid for a period of time, 2 years, 3 years, 5 years, whatever the court may deem to be reasonable. The point being is when it is a finding of a reckless credit agreement, it's a very, very serious allegation. And if it's found to be true, it has very dire consequences for the credit provider. They can even be deregistered by the NCR if they constantly engage in the practice of granting of credit recklessly. So it's a very serious impediment that's been placed, and credit providers do take it much more seriously these days. But the problem that we're having is, what does it mean when the person that applied for the credit never disclosed to the bank that they had the maintenance obligation in the first place? Because the one defense, and it's called the complete defense to reckless credit, is section 81.4. Now, what it essentially says is that if a consumer that applied for credit failed to fully and truthfully answer all of the questions put to him or her, and that would have materially affected the assessment that the creditor had done, then that would then constitute a complete defense. So in other words, what I mean in practice is, if a consumer applies for credit, does not disclose that he has a maintenance obligation, the bank doing its verification looks at the bank statements, sees no maintenance being paid. We know why, because the bugger's not paying maintenance. There's nothing on the credit bureau reports, despite the sections that are referred to earlier in the Maintenance Act, because at the moment, none of the credit bureaus are listing maintenance orders. Then the bank is not able to verify the truth of what's being said. So if there's a lie and the bank, in doing its verification process, is not able to pick up there's a maintenance order, then they could rely on this being a complete defense. So in other words, even if it was recklessly granted, the bank wasn't able to pick it up on the information available to it, then they can rely on section 81.4, and then the person would be fully liable to pay the debt in its entirety, and in terms of paying the full interest over the extended period of time. And that is then where we're sitting with a situation where we have all of these other credit obligations, and then the person comes to the maintenance court and says, I can't pay. Keep on knocking this over. I can't pay. Look at all my accounts. And what we're trying to do, there is a credit bureau with Marina Short. They are looking to list it with the app. So in other words, if you get your maintenance order, you log onto the parenting app. You can then upload a certified copy of that maintenance order onto the app, which gets sent through automatically to the credit bureau. And they said in future, they will then list those orders. What that means is, in terms of what I just discussed about a complete defense, if the credit provider knows, wait a minute, of the 13 to 50 bureaus that are available, there's one credit bureau that does list maintenance orders. And if they fail to verify with that particular bureau whether there is a maintenance obligation or not, and it is listed there, then this complete defense would fall out of the way, because then they didn't, even though the person lied, they could have verified it properly and wouldn't have therefore materially changed the assessment process of the bank had they ensured they drew the correct credit reports from the correct credit bureaus in order to have all the information that they have available to it. So there's a very important movement and development in the maintenance field where we're going to have maintenance orders being listed, and that has a massive implication on everyone here in the country, because it then means that a person that's in arrears with the maintenance is going to have a massive difficulty in terms of accessing more credit. Not only that, some of the credit can be written off in terms of reckless credit, and that then goes to the affordability of being able to pay their maintenance, and not only to be able to pay their maintenance, but also even to be able to pay a higher maintenance, because they now have less credit obligations and they don't have access to credit unless they fulfill their obligations in terms of their maintenance in the first place. Next slide. This extra slide I've included at the behest of my fellow brother and colleague over there. And it's actually something that's very important. And of all the things that you're going to take from today, I want you to remember this slide, or to get the PDF with these sections of the Act. So when you go to court, you are then armored with what rights you have, not just in terms of the Maintenance Act, but also in terms of the National Credit Act. And what it says is the following, and please guys, this is the important part. Section 83(1) states that despite any provision of law or agreement to the contrary, in any court proceedings in which a credit agreement is being considered, the court may declare that credit agreement reckless. And in Section 85, it takes it further, or the court might order that particular person who has that credit agreement to be found to be over-indebted, and either to make an order to restructure those debts. What that would mean is, say the person has the Isuzu Bucky of 5,000 Rand. If it's not reckless in those cases, the court can order, I'm going to restructure your 5,000 Rand installment on your vehicle. I'm going to restructure it at 3,800 Rand, and thereby freeing up 1,200 Rand, which I can then allocate towards your maintenance. So I want to emphasize this. If you take this section to the maintenance court, they're not going to know what you're talking about, because the maintenance court does not deal with the National Credit Act. But this is something that's got to change. There's got to be a training with regard to what rights and what obligations and what law is available to a maintenance court and to the maintenance officer that they need to have available to them, that they can enforce to the benefit of maintenance being claimed and to the benefit of maintenance increases being asked for. The point being is the following. They might argue, no, but this section doesn't apply to me. First of all, it says despite any provision of law. So it says no matter what anything else says, this section is of relevance to the following circumstances. It goes even further. It says in any court proceedings. Any court proceedings. How much wider can you have than that? You can't broaden it any way further than that. And then it even goes further than that. It says where a credit agreement is being considered. Not where credit agreements being enforced. Just considered. So in other words, the maintenance officer or the maintenance magistrate might say, no, this applies for when a bank's suing someone. And in that court, when they're busy looking at that credit agreement that's being sued upon, on the house or on the car or on the credit card, saying, you know what? Sorry, throat dry. You can see I love the law, so I get very passionate. Okay, so they say, you know what? This agreement looks reckless. I'm going to refer this to a debt counsel. I'm going to ask for some discovery documents and ultimately make a declaration that is really reckless and write it off. But that's not what it says. It doesn't say in the enforcing court of that credit agreement. It says where credit agreement is being considered. And the word considered is also very broad. So you can make an argument that when the maintenance defaulter comes to court and he brings all his bank statements and all his credit cards and all his house payments and the car that he must pay, and he shows, here's my credit agreements, I have nothing left to pay maintenance. Then you can tell that maintenance court, listen here, no, wait. Some clever guy told me, look at Section 83(1), look at Section 85 of the National Credit Act. You are busy considering these credit agreements. This is a court process. Let's make a finding in terms of whether it's reckless, or let's refer this person to debt counseling and have his debts restructured. What does it mean as well? If a person's referred for debt restructuring, debt counseling, debt review, the moment that notification, that order gets made, that person is then barred from accessing credit anyway until the person goes to the debt counsel, and the debt counsel has to do an assessment of finding whether that person is over indebted or not. The moment the debt counsel makes a finding that the person is over indebted, that person is then barred from accessing credit no matter what happened at the maintenance court. So yes, we need to sort out the existing debt, but going further, it's also going to stop that person from being able to access any other debt or any further credit while they're busy fighting on their maintenance that they say they can't afford to pay. If they can't afford to pay their maintenance, then as sure as hell shouldn't be getting access to any more credit. Sorry. So, in summation, I don't know if I went over my time, so I'm going to keep it quick. In summation, what this is all about is the sustainability of maintenance. It's absolutely pointless to have a maintenance order that a person must pay 150,000 Rand per month if they can't afford it. It's not enforceable. You're not going to get 150,000 Rand per month. It depends on the financial circumstance of both parties and the needs of the child. But by the same token, we need to ensure that maintenance is something that's sustainable, not only now, but over an extended period of time, that we know that it's a process that's going to be paid each and every month. We don't want maintenance defaulters. We want maintenance to be paid. And there are various ways and means that we can do so in terms of everything that are said. So step one, if we have the credit bureau listing of the maintenance, the moment they're in default and then they go apply for more credit, whether they're under debt review or not, if they go apply for more credit and it shows they defaulting the maintenance order, that credit provider should not be granting that person credit. Because if they can't meet the existing obligations, they shouldn't be accessing credit. Step two, it gets built into the affordability assessment that when a credit provider is busy considering granting more credit to that person, it has to take into account those maintenance orders and obligations and the defaults in terms of that order, which in the future is also going to be listed on the credit bureaus as well. Because you've got to bear in mind, when that person goes to apply for credit, the ex-wife, the mother of the kids, is not there. It's just the guy, and he wants his bucky. He's going to say what he needs to say. So it's important that we put these processes in place that puts the obligation in the credit provider to decline their credit, because if they're granted and they have the risk of it being declared reckless, well, then there's very severe consequences for the credit provider. And then finally, in terms of step three, as I said, it then affects the access to credit. So if you have a maintenance obligation and you want to go and get the new car, or you want to, I don't know, whatever you want to go get in terms of credit, then you know, now son, you know what, I better pay my maintenance every single month. Otherwise, I'm going to have a problem down the line when my new girlfriend wants a new fancy car. So it's important that all of these processes are in place, because if you can block the access to credit, it ensures that there's a better chance it's going to ensure compliance with the maintenance order. And it's a strong motivator to ensure compliance with those orders, to compel those people to pay, because it's going to affect their credit profile. And I'm sure that's one thing they don't want going further, especially when they want to start their new life. They want to start with a clean slate. And if they want to start with a clean slate, they must make sure they meet the existing obligation in terms of maintenance. So that is, in a nutshell, how one can take two very different acts and apply it in the maintenance field in a very positive way that can make a massive change in terms of enforcement of maintenance and the sustainability of maintenance. But all we need to do is we need to ensure we have training, that you know what your rights and obligations are, and you go fight for it. You advocate for yourself. And if the maintenance, and if it happens enough, the maintenance officers and the maintenance magistrates will become more familiar with the law and more au fait with regard to what authority they have. And that authority can be wielded with devastating effects. And that is why I think we should do whatever we can to try and protect the maintenance, the sustainability of maintenance, and ensure that we have orders that are enforceable and to do so in a practical way, as opposed to just what's on a piece of paper, what's in legislation. All right, thank you very much. Do we have time to deal with questions? Okay, cool.
Hi, thank you so much. That was very informative. I have a question about credit cards.
Yes.
So, my son's got. Do you want to go to the press?
So, because then the people online can hear.
Hi, everyone. So my question was regarding credit cards. So obviously, I'm not exactly sure how the credit is granted, but based on your salary and things, and sometimes they grant you more credit.
Okay.
So how does
I'll
that get
explain
dealt
it.
with to
Explain it.
reduce the amount of credit
Okay.
available on a credit card?
Okay. So with regard to a credit card is a facility. So what that means is that you get a credit limit. So let's just use an example. You apply for a credit card of 20,000 Rand. You have a credit limit of 20,000 Rand, and you've got to keep your debt within that credit limit. So if that's an existing debt, then obviously that is something that the maintenance court has to take into consideration. The problem that comes into it is what happens when that person who then applies, who's got a credit card 20,000 now wants to increase his limit to 50,000 Rand. In terms of the National Credit Act, the bank is specifically required to do a new assessment. They can't just change from 20,000 to 50,000 Rand. So when they're doing a new assessment, they have to relook at that person's financial circumstances, and that's again income, affordability, what maintenance obligations there are, and then determine whether the person can afford that increased amount in terms of the credit limit. So there's knocking this thing up. There's an affordability assessment that is required to be done afresh, as if it was a new credit card being applied for. I hope that answers your question.
Thank you. Good morning, everybody. My name is Lynn. I'm from Mitchells Plain. In Mitchells Plain, we have very sophisticated defaulters. And I'm going to raise the reason why I'm saying so. In the court of law, you need to prove beyond a reasonable doubt.
A balance of probabilities.
Yeah. So for me, the challenge that we have, say I have a defaulter, unemployed, but he took his money, become a loan shark, not by the credit. We have this loan sharks in
Yes,
Mitchells Plain,
yes.
which they charge people 50%, 100% interest.
Yes.
But the money is not in his account because you pay a cash, and then they have the family. How do we overcome that challenge?
Okay,
Because the money will go into the
okay,
family
it's
and stuff.
quite simple. This is a maintenance order question, but I can answer it. The maintenance court and maintenance officer, as well as the investigator, they can be investigated, and those family members can be subpoenaed by the maintenance magistrate to come to court with their own bank statements. And then if they come to court with their own bank statement that shows, 30,000 Rand that's coming in, they need to explain, what is this money? So if they are basically a front for the defaulter, they have to provide a reasonable explanation. The maintenance officer is going to believe of where that money came from. So if it's coming from the other guy and they can't show where else the money is coming from, then the court can make an order. No, listen, this is actually your income in someone else's account because you can't verify where this money has come from. There's no foundation for it. And also to bear in mind that if the person lies on the stand, it's perjury, which is also a very serious offense. So a good cross-questioning, it doesn't matter how sophisticated they are, as soon as they rope in family members and they've got to come to court and testify in a court, and there can be very serious consequences, and they're covering for someone else, you can get it out that way. And then the maintenance court can take that income into consideration in terms of a subpoena and calling those witnesses with whatever documentary proof that they require. All right.
Also for on the money laundering, when you're using someone else's.
Yes, that's a different aspect, but that's a criminal thing. We're trying to deal with maintenance there. So I'm trying to limit the issues as much as I can.
One more question for you, sir.
Go for it.
There's an online question from Imbavani Chetty. She says, should a court order state that the respondent, the father, should pay maintenance, and that is specifically school fees? And the order says that the school fees must be paid directly to the school. But then you default or he falls back on the payment. Whose responsibility is it to follow up on the outstanding payment with the court? Is it the school's responsibility or is it the mother's responsibility? And then there's a follow-up question, who is accountable for that shortfall, that default in the school fees until it's resolved? Is it the mother or the father?
I don't specialize in maintenance, but I can answer these questions. Okay, so when it comes to school fees, both parents are legally liable to pay the children's school fees. A court order is an order between two parties. It doesn't include the school. So in other words, there might be a court order that the father must pay the maintenance, but when the school sues, the father must pay the school fees. But if the school sues for the school fees, they don't just have to sue the father; they can sue both parents. Because that's a court order between two parties. It's not binding on the school. So when it comes to whose obligation is in terms of paying, it's actually both parents. But then one can go back to the maintenance court, say this person's defaulted in terms of the obligations, And this is where this whole thing kicks in about where if those defaults and those orders can be listed on the credit bureaus, then that's going to have a massive impact in terms of again, that enforcement of it, sustainability of it, and being able to, and they won't be able to access any more credit. So if he's not paying, that father's not paying the school fees, he's going to have a problem getting any clothing account, anything in the future going forward. He's not going to be able to access further credit until he's brought everything up to date again. That's the whole idea of what we're trying to do here. All right. Okay, thank you.
Now, that level of energy we had at the Institute for Social Justice too, when Mr. Zimmerman was speaking to us over there. And if you think that is contagious, you must see his wife, Robin Zimmerman, when she takes over. The two of them are quite a power couple whenever it comes to this. Thank you so much, Anneke Guyvenstein, for allowing us to let Mr. Zimmerman come and speak to us. I did ask him and he didn't say yes, but I always ask the why first, because the government, you need to start with the government and then you get things done. So I'm going to ask Mr. Zimmerman to, for 2028, also elaborate even more about the National Credit Act, because the more it's in the face of everyone to understand it, because fathers, and I'm sorry that I'm saying fathers, but unfortunately, 98% of the cases in the maintenance courts in South Africa are fathers that are the respondents, and they always come with the excuse they are over indebted. But there are case law as from 1939 that says that in a case where a father is indebted or whatever the case might be, first priority is the children, not his what skuld soveel, how much he owes. That's immaterial. There are cases, Scott versus Scott, and then 1946, WLD 399, and then also Mulder versus Mulder. I see people are writing Scott versus Scott, 1946, WLD, page 399. In that case, in 1946, it was already said that where fathers are owing a duty to maintain and they do not maintain, then in those cases, it will go on in a few seconds. If we filled up the diesel in the tankers downstairs. So just give it a few seconds. Are we still online?
Yes, we are.
Okay. So there are two cases, Scott versus Scott and Mulder versus Mulder. In those cases, the father's duty towards his children comes first. He cannot come with an excuse of nobody's over indebted, he must pay all his skuld. We're not worried about that debt. The debt will come second. But first will be his duty towards his children. Section 7, the best interest of the child is what is then the yardstick that we will then measure it accordingly. Thank you, Quentin. Just lights over there at the panel at the back, and then it will go back on. Yes, thank you. Next up, I will ask Michaela Jackson to come to the podium. I know it's not according to the program, but I asked Michaela if she can do her presentation on wills early, so that she can revert, and if there are anybody that would like to see her, then people can speak to her regarding a will that they would like assistance with. Michaela is an attorney. Michaela Jackson is an attorney, and she deals with wills and estates at the firm where she is working at. But for those of you that would like to get a will drafted, she's willing to do it free of charge if it is being done over here at the NPA. She will take your details and she will consult with you and get all the details, and then she will be able to assist anyone. And one thing that we need to encourage people to do is to make sure that they have a valid will as early as possible. Whether you live in Manenberg or in Grabouw or wherever, it's important that you have a valid will that will somehow deal with you. So we got the expert over here. Michaela can come down, and she will address us on how to compile a will, what a will is, And presentation is quite short. It's just an introduction, and then whoever needs to get a will, we will make a facility available, or you can sit in the cafeteria and have some chips while you are negotiating or getting then the information to Michaela for her to assist with the will. Michaela?
Good morning, everybody. My name is Michaela, and I will basically just be discussing the gist of it, what the will is, what you need to do to make sure that you have a valid will in place, and the importance of having a will and the possible consequences if you don't have a will. Okay, so a will is basically just a legal document where you will reflect your last wishes. You will state in your will how your estate shall devolve upon your passing, who your beneficiaries would be upon your passing. You can make special bequests. So a special bequest would be anything that has maybe been in the family for years and years, or it is of sentimental value that you would like a specific person to have free of any conditions, that we would call a special bequest. You can do that in your will. You can list your instructions as to how you would like your mortal remains to be dealt with after you pass on. Would you like to be buried? Would you like to be cremated? Do you want a funeral service? Do you want them to do any specific things that we call a wish? So you can add in all of those little things, all of those specific wishes and instructions in your will as well. And what you can also do is you can nominate guardians if you have minor children. So upon the passing of the natural guardians, you can then have one or two or three nominated guardians in your will, which you can ask to take care of your minor children upon your passing, if they are still minors when you pass on. So the Wills Act does have a few requirements in order for a will to be declared valid. Okay, so for a will to be valid, it has to be signed by the testator or the testatrix, which is the person creating this will. It has to be signed on every page by the testator or testatrix. It has to be signed in the presence of two witnesses at the same time. Okay, the two witnesses also have to sign your will on every page, and they have to be over the age of 16 years old, and they need to be able to appreciate the nature and consequence of what they are doing. So they do not necessarily have to read your will. They do not have to know the contents thereof, because that is personal to you. But they just need to be able to understand what they are doing and what they are witnessing to. If in an event where a person cannot sign, it happens sometimes that somebody cannot sign their will, in that case, it will be certified by a commissioner of oaths. In any other event, it is not necessary to have your will certified. So then the commissioner of oaths will then sign alongside the testator or the testatrix and the witnesses, and they will certify the last page, just to say that they have satisfied themselves as to the identity of the testator and testatrix, and the testator will then make a mark as opposed to signing. So a fingerprint would be sufficient in that instance. Okay. There are certain instances where it is important to have a will, and I want to touch on minor children particularly. So if you have children who are under the age of 18, it doesn't have to be your children, any child that you would like to inherit in terms of your last wishes, and that child is under the age of 18, you can create a testamentary trust within your will, whereby you will say, I bequeath X, Y, and Z to this particular person, but it will be held in trust until they reach a certain age. The age specified is up to you. If you feel somebody cannot handle responsibility, let's say by 18, which is the current age of majority, you can then say, okay, let the trust age be 21, 25, or let it pay out half at this age, half at the other age, whatever the case may be. So that is up to your discretion. Your trustees, you will appoint yourself. Your trustee will normally be a firm of attorneys or a particular institution together with the person that you nominate and appoint. So it can be somebody that you trust that will then administer and control the child's inheritance until they reach the particular age alongside your attorney or whatever the case may be. So that is good. You then have a measure of control, if that makes sense. Um, and like I said, why it is also important is for the guardians of a minor child. You can say, I would like this person to look after my child when I am no longer around XYZ. Okay, so I just wanted to touch on the minors part, why it is important to have a will in the instance where there are children that will be involved. And then also, if you have a beneficiary who is married that you would like to inherit in terms of your will, even if that person is married in community of property to their spouse, you can add in a clause in your will saying that your person will, your beneficiary will inherit, and that inheritance is free of marriage in community of property. So that will, the spouse will then not have a claim against any inheritance from that beneficiary. It is important to bear in mind that if you are married in community of property, whether or not there is a will in place, your spouse is automatically entitled to half of your estate. And it is your half share that you have the liberty and the discretion to decide how you would like for it to develop. There are a few consequences of not having a valid will, and I'm just going to touch, it's going to be a bit repetitive, but just so that people understand why it is important to have one in place. So if you don't have a will, your estate will devolve according to what we call the Interstate Succession Act. There are various factors that we then have to consider when we administer the estate. We have to, that book will then guide us, or the law will then guide us. And who will inherit according to the Interstate Succession Act will depend on various factors. Every situation is different. So things like the deceased marital status will be a factor when we are sitting with an estate and there is no will. The value of the estate will be important. And also we look at the closest blood relation. So there's lots of factors that we will then have to take into consideration. We have to follow the Interstate Succession Act as opposed to the person's wishes. Whether or not you spoke to your family and said, this is what I would like to happen, it is very important to put it on paper so that it can be executed accordingly after your passing. And also, if you have a child, a minor child or minor children, that will then automatically inherit according to the Interstate Succession Act. That child's inheritance will then be sent to the Guardians Fund. The Guardians Fund is a branch within the Master's Office, and that child's inheritance will only be paid out to them when they reach the age of 18. Whereas if you have a trust in place, then it can be administered accordingly and according to your wishes, and the trust will also terminate upon the age that you decide, when then the child will be paid out accordingly. So this is just a nutshell of what is important and why it is important. If anybody has any further questions, my details are on the slides. You are more than willing to contact me. You can call me, you can email me. And if you would like to have your will set up accordingly, I will assist. Okay? Thank you.
Thank you. I can also proudly say that I was involved with Michaela when she was a student at UWC, and she attended a program that I facilitated at Wynberg Court. And this is what came from Wynberg Court after all these years. So well done, Michaela. And that's what we need to do. We need to empower women to take their rightful place, whether it is in the legal fraternity or wherever. And that is what we're going to do. We've got beautiful, capable women of color that can take up their rightful place. And luckily, we've got two of them that we will showcase today. That is Michaela, and then later on, Advocate Yasmina Muhammad will also have an opportunity to then present on her presentation, just empowering women today. But in future, Advocate Muhammad said that she will support the NPA community dialogue in different other ways, and even take up some of your cases that needs to be taken up to a higher level in the High Court. and deal with it at that level. So we've got powerful women in this room today. The more powerful I'm going to introduce a little bit later. Ms. Pearl Walsh joined us, and she's going to give quite a powerful um, I can't call it a speech, it's more than a speech, but you will hear when once the dynamite starts to explode in here, then you'll hear what I mean by it. Before we get there, I thought it's also important to follow up on the presentation that was done last month by Anneke Guyvenstein on the different apps that are out there and that can make it a little bit easier for us to just navigate our way through the family law courts and be able to do some of these things that we are supposed to in order to get information to mothers, and how we can get that information to make sure that they are equipped to be able to deal with the different cases pertaining to the maintenance matters, children's court matters, and any of the other matters. So next up is going to be Ms. Nopinki Jalangezi. Do you have your presentation on a flash drive for me, please? Or do you want to use your laptop? Then you'll be able to.
Thank you very much, Advocate Dion. Greetings to everybody that is here, and a big thanks to Anneke, who has made it possible for me to be here. I first want to say that I consider it a privilege for me to be here, and I'm really in awe of such a forum and what it is doing, and really wish more women could be aware of it and come and partake. In fact, I will do all that I can to make sure that those who need it become aware of it, because really it's some serious empowerment that is happening here. I'm really grateful to all the experts in law and experts in whatever community service and in anything that they are doing, who give off their time to do something like this. When I was here, it was my first time last week. I really was in awe of what is happening here. So thank you, Dion and your wife, and everybody else. This is really special. I want to say that my surname is Jilingisi, because it has to be, no, it's me. I came with it because it's our marketing department that has to prepare, because they're very specific about how everything must look. Because I know my name, that's the last thing I checked. So only now I realized that my surname is not spelled correctly. So apologies for that. It's actually Jilingisi. Okay. I am here to speak about the OKDoc healthcare ecosystem. It is provided by Remote Doctors for All, which is the healthcare ecosystem that provides the services of various health services to the community, to practitioners, and basically to everybody on the street, that they can have health services that are very high level in the comfort of their home if they choose to, even though they can be able to go or get a specialist to come to them. Specifically today, I want to speak about how our offering, which we do through an app called OKDoc app, how it can help and assist in the pandemic of gender-based violence and domestic violence and any kind of violence against women and children in general, even though we know there are other minorities that get affected by it. Okay, we all know, I'm sure in this forum specifically, what the pandemic is of gender-based violence. Actually, it was a horror that the pandemic we came out of turned out to not actually be the real pandemic if you consider numbers, that all along we've been living with the biggest one, which is gender-based violence. And it became exacerbated by the COVID-19 that we came out of. The stats are really staggering that came out with the United States women reporting in 2021 that as close as 50% of women are either directly or know somebody directly who was affected by gender-based violence. And we can see that really, that is worldwide. And we see that really, this is really a problem of great proportions that forums of this nature do well to gather. And it is really something that is a desire, I'm sure, of everybody that is here, and especially for me, to make sure that what is being preached here and what services are being offered here do not go to waste. We all know that the gender-based violence knows it does not discriminate. It knows no color, it knows no age, it knows no ethnicity, basically. It is something that happens, and it can happen anywhere and everywhere. And unfortunately, women and children are the most that are affected. Like, just to speak about stats, about around 736 million people are subjected to physical or sexual violence by an intimate partner, somebody that they know. Even if it's somebody that is not an intimate partner, but most of the time it is somebody that is not a stranger to the victim. Okay. And some of the problems that we are looking to address with our app are such statistics. And we know that with the victims of this pandemic of gender-based violence, fear is an issue. And we know that being serviced by police in a way that is very sensitive to victims is an issue, because as a result of all of this and the stigma that is associated with it, as a result of this, most women do not speak out, or they feel scared to speak out, or they feel ashamed to speak out, because as services that are available to them, they make them to feel even more ashamed in the way in which it is dealt with. So the solution that we are bringing through the OkDoc app is looking to address some of these problems. The solution that we have, as I said, it offers a health ecosystem, either on a web app or on a mobile phone. What does that mean? It means that some of the problems that we have addressed of being assaulted by an intimate partner in the comfort of your home, sometimes the women might feel ashamed to go out or even speak out. Now they can do something in the comfort of their home. They can access the app. They can, the services that are available to the app is that they can either request the services of a specialist, a nurse or a doctor. They can either come to their home with a test kit. They can request the services of a counselor that will either come to their home, or they can have a video conference with them. That addresses the issue of if they don't want to go out there and present themselves, or if they feel that if they go to the clinic, as we know that the community health services or centers, they don't sometimes treat very well. I know of cases where women who had just been raped, or even children, they go and they get sent back. There's 2 cases that I know of that the women actually died from that. You ask yourself, how is it possible that somebody that you can see that are suffering from this violence can be turned away or not even believed by the people that are supposed to help them the most? So this app helps, because now they get the option to not go there to request somebody to come to them, either by means of a nurse or a doctor. They can also request to have a video conference where the health services practitioner can attend to their needs. And because it offers both a video, they have the option that if they feel ashamed, they can switch it off. They can only have audio. And the services that we offer, they even offer a chat system that they can chat to whoever is providing the help, counseling them, or trying to take the evidence of what has just happened, or somebody who's trying to counsel them with the mental trauma that they will be experiencing at that time. So the app, what it does offer, it offers a secure sign-on. I don't know if you are once slide ahead. You can go behind. Yes, it's actually the third one. One before. Yes, thank you very much. It offers a secure sign-in. It offers a health and wellness tracking. It offers a full communication platform where you can either have video or chat. It offers the patient's secure records because the patient can enter their medical records, or at the time when they are having the consultation, it's got the opportunity, it's got the facility to transcribe, and it's got the facility to add documents. It's got the facility to capture notes for the practitioner or the counselor that is speaking to the victim to capture the notes, and it is saved securely, and the patient owns the record. In other words, they can only share that record with whoever they want to share with. Now, just to speak about the security of this consultation, because the first thing you would think about is that, okay, you will have a video conference, you will save this information, is of a sensitive and intimate nature. What does that mean? The video conference that happens is that there is a secure link that gets sent by the specialist to the victim. So that link is only encrypted, and only the participants of that session are able to take part. So it cannot be, nobody can be able to have access to that. And also the records that are produced from that, they get stored in an encrypted form, and only the patient will be able to give access for the people to share or to have access to the information or share it. The app also offers a medical device telemetry where there's a kit that the doctor can either, or nurse can either take to, and they monitor the vital signs of the patient. They've got a kit that the counselor who will go maybe to counsel the victim right at the time when the incident has happened, they will have the actual kit that they need at that time. They'll be able to attend and will solve the problem of not being able to have evidence, because if the victim maybe is feeling shame, they wait a few days, then some of the evidence is destroyed. So this solves that problem. And the way in which it is done, it's done in a sensitive way such that at any point, if the counselor will be able to assess the comfort levels of the victim, and at any point, if they don't feel comfortable, they can be able to postpone the session, and they can stop at any time to adjourn to another time for the solution, for the consultation. We can move to the next slide, please. Okay, I've spoken to most of it. It's got video and it's got voice, and it's all done in a secure manner that is only accessed by the participants to the session. Next slide. What differentiates us from the rest? Because we know that there's a lot of available solutions there online, or some people might offer some aspects of what we offer. We offer a full ecosystem. That is, firstly, we provide our app that is enabling either the victim or somebody who knows the victim to call a doctor or to book a video conference or book an appointment if they should want to go to the specialist. Firstly, they'll be able to access what doctors are available in their range. They will be able to assess if, okay, I want to go to one that's next to me. They'll be able to assess if I want to access a doctor that is known to myself, but I don't want to go, I want to do that via video conference. They'll be able to make that determination. And especially, or not only will they be able to do that, we are, because it's an ecosystem, we are able to integrate with other medical health providers. The doctor can write a script, and it can go off to the the pharmacy for the patient, and the script can be saved and adding to the record of the patient, and it all adds to the history. Should the patient wish at any point in time to lay a charge, it will be entirely up to them, but they will have the tools to be able to do whatever they need to do with the information. Again, as I said, the customer owns the record. And it has a full communication. They can chat, they can video conference, and there is a medical device telemetry that can be on the accessed via the web or via your mobile phone. Okay, move to the next slide. These are just examples of a doctor going out there in the bushes, child going into the doctor's office or going into the clinic. Okay, what benefits we offer? We are able to bring quality health services wherever the patients are in general, wherever victims are in general, in the comfort of their home or in a manner that makes them feel at home, that makes them feel comfortable, okay? It solves the lack of access in the rural areas. It helps the patient to adhere to medication because we offer a calendar that shows the scheduling of when they are needing to take their medication. It makes sure that care gets to where it needs to timely and in the comfort of the person's, according to the person's comfort, either at home or in privacy via video conference. And it gives the access to specialists because we know that we have some ladies that work with us from parts of Africa. The one part that they talk about is that, okay, it's fine, we have doctors, but the issue that we have most of the time is access to specialists. So what it does help with is that patients can have access to specialists and quality care wherever they are, not limited to their geographic location. And you can only get a better outcome from that. The next slide. Just to show you the picture of what the app is, we have the web app. It's got all of that menu where you can get either as a doctor or as a patient. You can get the menu of the home where you can add your details. You can be able to book a consultation. You can be able to see your calendar of consultations that you have had. You can be able to see your medical history if you are a patient. If you are a doctor, there it brings the calendar. So you can see your calendar that comes up and what is it that is lined up for the day for you. It's got quite a few functionality that it offers. That's just the picture of the web app. The phone app, you can see, we try to make it look appealing and neutral colors, because we know that people of today, they love things that appeal to the eye. So we try to adhere to that. There you can see as well that you can see as a patient your appointments that you have, and as a doctor, you can see who you are meeting with at that time. What is not shown here is the assistance with your, like for example, if the patient is to take chronic medication, the calendar does show the scheduling of that as well. And it will also show whatever consultations that they have had in the past and who they have seen, and if they would like to access the outcomes of that, all at a touch of a button, they can be able to do that. The same with doctors as well, but with the medical records, only with the consent of the patient. The main thing that it's centered around is the consent, informed consent of the patient. Okay, we have some partners who are working and collaborating with us, as mentioned here. Yeah, basically, it is a platform that you can have as a platform of choice because it gives you the freedom that you want. You can do the traditional, visiting a doctor, you can do video conferencing, or you can sit at home and have a medical healthcare worker come to you. It gives you all of those options. That is all. Thank you very much.
You're welcome. I will reserve the questions for a little bit later, but if you want to ask questions to Nopinki or to Anneke, or I see Laurie Guyvenstein also joined us. So if you want to ask any questions, please, you can. Even during my session, if you don't have any questions on international matters asked during my session, Laurie as well as Anneke will be here to answer any of those questions. Or if there's something that you think about now or would like to ask later on, please do ask any of the questions that you'd like to ask. I see Pearl is jumping up and down there. I know. So that's why I just wanted to quickly say that the handouts is not in your handout, and also the online viewers, the handout that I sent does not have Nopinke's presentation. But those of you that would like to get it, please just send me an email, capital D, capital R, dwriters@npa.gov.za, and I will send it during the course of today. But by this evening, it will be in your inbox and you will be able to then have it, as well as Nopinki, Anneke, and Laurie's details. I will make available to you in case you have questions but that you'd like to ask to any of them, then you will be allowed to ask that. I will hand over to our MC, Ms. Welsh, and she will then take over from here.
Good morning, ladies and gentlemen. My name is Pearl Walsh. I was due to be here earlier this morning to do the emceeing. Sorry, you're laughing, Advocate Raiders. I was supposed to introduce Advocate Raiders now after Madam Gilingizi's presentation. Thank you very much for your support to gender-based violence. Thank you very much to Mr. Zimmerman for his presentation this morning on the National Credit Act and maintenance. I would like to introduce you now to none other than the Advocate Raiders to do his presentation on how you would apply for maintenance from respondents in foreign countries so that we as South African women are able to protect ourselves and our children when we have partners that is able to flee so freely back to Europe and not take the maintenance responsibility. Advocate Raiders, if you do not mind to come back. So my session is on safety and security after all this maintenance and after the financial disarray on maintenance. So I would like to call you back for your presentation on the maintenance, please. Oops. I would like to mention, thank you very much for all of you as colleagues and associates for what you're doing on supporting women and children, whether it is for the safety and security, for child maintenance, looking at how we can try to build a better future, trying to activate and insist on our system being able to, sorry, my throat. Thank you. Let me just do the water thing so my throat is dry. In order for our justice system to work better and function better for what we already have implemented in our Constitution. Advocate Raiders, we would be happy to have you back now.
I'm so sorry that I did that to you and not prepare everything properly over here. But that's how we learn and get things sorted out over here. So what I'm going to be doing is a presentation on what is supposed to happen in a case where the mother comes to the maintenance court. She's got a person that is or a father that have responsibilities towards a child, and this person is in a foreign country, be it in any of the countries outside of South Africa. Then what does she do in order to then gain some type of information in order then to be able to assist herself in the process? Number one, the Department of Justice have a policy document. It is called the Department of Justice Family Code on Maintenance, and it is 26 of 2015. In terms of this policy document, they have got certain responsibilities whenever they are dealing with any type of foreign matter. And there are two pieces of legislation that is being used whenever they are dealing with these type of matters. The one piece of legislation is the Reciprocal Enforcement of Maintenance Orders Act 80 of 1963, and the other one is Act 6 of 1989. I'm not going to bother and bore you with all of those details. That's not important. I've learned from Mr. Zimmerman, don't do that, just do the practical part. So I'm going to try and implement what Mr. Zimmerman said and do it practical and make sure that all of you at least have a basic understanding whenever you are going to be dealing with it. So please don't go and look in the Maintenance Act for answers. You're not going to get any answer in any piece of the maintenance legislation. You need to look at the Reciprocal Enforcement of Maintenance Orders Act 80 of 1963, old act, or you need to look at the Africa Act, Act 6 of 1989. You will be able to find it on SAFLI in case you are looking for it. So go on SAFLI and you will find both these pieces of legislation in case you want it. The regulations is a little bit difficult to find, but if you do need it, please just drop us an email at info@childmaintenance.org.za or go on our website www.childmaintenance.org.za. You will find the full presentation or the full regulations on that piece of legislation that you can use. But what is the most important thing to start off with whenever you deal with these pieces of legislation, those that are following page 12 of the handout? That's where I am right now. And the first thing that I want to tell you is, if you want to know which countries are the countries that are involved, or to which countries we've got a direct reciprocal type of agreement, then please look at page 17. On page 17, on page 15, let's start on page 15. On page 15 is all the countries that is involved in some type of an agreement or relationship with South Africa. So if the lady comes into the maintenance court, then she needs to be able to tell you in which country that person is. That's the first step. She needs to know where he traveled to or in which country he is. Once we know that, then we've got a starting point. So those countries that are mentioned on page 15 are the countries that that South Africa have a reciprocal agreement with those countries, that we are going to deal with those matters whenever it is in any of those countries. Page 16, the other countries are also listed. But what if the country is not listed? Then we look at a different type of document called the UN Convention on the Rights of the Child. That is a different piece of legislation, also dealing with relationships between South Africa and their foreign countries all over South Africa, or not all over the world, that have a relationship with South Africa. So if the Africa Act or the Act 1963 Act do not cover as a list any of those countries, then you move to the UN Convention on the Rights of the Child in order then to see if in any of those pieces or if any of those countries have some type of reciprocal relationship with South Africa. That is where you start off with. In most cases, if it is not on the Act 80 of 1963, it's not on the Africa Act, and it's not on the UN Convention on the Rights of the Child, none of those legislation provides for the country where he's in, like the Cayman Islands or wherever he's hiding. If it is not a country that South Africa has some type of a relationship with, then in those cases, then the lady will have to appoint a barrister or an attorney in that country to pursue it on her behalf in that specific country. So hope and pray that it is in terms of the Act 80 of 1963, in terms of the Africa Act, or in terms of the UN Convention on the Rights of the Child. If there is no treaty between South Africa and that specific country, we can't just go and enforce it in that country. There must be a diplomatic relationship between the countries. Else, if there isn't one, then we will have to make some type of a relationship or start a relationship with that specific country, like quite recently we had to engage with the United Emirates and all of those countries in order to get certain things sorted out in order to do and arrest people in that specific country. So that is what we will have to do whenever we deal with these type of cases. So the most important thing to start off with first is the reciprocating treaty between South Africa and that country. That's the first thing. Then what the maintenance clerk or the maintenance officer, and that is a duty in terms of the Department of Justice's policy. And you see that in page 40 of the policy document, page 40 to page 51 of the DOJ code on maintenance. That is the DOJ code 26 of 2015. If you Google for the DOJ code 26 of 2015, you will not find it anywhere on Google, unfortunately. Don't waste your time. You will not find the DOJ code anywhere on Google if you're looking for it. In terms of the policy document, they say that in every library, at every court, they must have a copy of that policy document. So those mothers that have to sit in the maintenance queue and have got their number, that they're number 15 in the queue, they're going to be heard 15 of all of the people after how many hours, then they can ask, where's your library? I want to go and see the DOJ code 26 of 2015, and then you can read that page 40 to page 51 and then see what they say as far as the reciprocal enforcement, international maintenance, and how they deal with international maintenance. So please don't look for it. You will not find it anywhere. But if you come to the 2023 NPA Community Dialogues, we will make that available to you. If not, you're not going to have it anywhere, wherever you're going to look for it. So now the lady is in the maintenance court and she needs assistance. First thing the maintenance clerk will have to help her with is what we call a deposition affidavit. A deposition affidavit is in terms of Section 8 of the Act 80 of 1963. It says that in the deposition affidavit, she must give more information about him. What is the relationship? How did they get together? Or what makes there some type of responsibility between her and the other individual? So in that deposition affidavit, she will say that I know Dion Reuters, I've got a child with him, and the child is this age, and therefore there is that responsibility. Then there is other documents that also needs to go with it. They call it the grounds for opposing it. She needs to put either in the affidavit or there's a form that is completed or that is part of the DOJ code, and that form is the grounds for opposing the specific application in the country, wherever the case might be heard. And that form is on page 25. If you look on page 25, that is the document that she can then also complete with her founding affidavit. She needs to give her grounds on what might he say. Yes, he may continue. No, it's not my child, or whatever he might say. Or no, but I'm paying my maintenance. Why is there this specific case coming forth? Any of those type of things that might be said by the respondent, she needs to cover in her grounds as what he might say whenever the case is being heard in the other country. So she needs to make sure that she will cover some of the bases that he might use as an excuse in the other country to somehow say that, no, but you court don't have jurisdiction. You can't come and drag me to court if that is not clear. So the forms that needs to be completed with the deposition affidavit, you find on page 40 of the DOJ code 26 of 2015. And you are fortunate being here today, and the online viewers, it is, the forms are over here in your handout, or it is on the online handout that was sent to you. So the one form is NHV, and that example is on page 119 of the DOJ code. Form W, that is on page 122 of the DOJ code, and Annex X, that is the court order, that's on page 123 of the order of the DOJ code. But specifically statements on the grounds, I showed you where the statements are. And then what is also important is you need to give a most recent photo of him. What is the reasoning behind that? Whenever the sheriff in the county, not country, in the county, wherever he is, when they're going to go to that house to go and serve the documents, and listen, you need to get to the court in the foreign country, they need to see who they are speaking to. Because what some of them do is, if the sheriff comes and asks, now, where's Dionytus? Then I say, no, I don't know him. And I get good buddies of mine, Mr. Quentin Zimmerman. Quentin, where's Dion? No, I don't know. All of us don't know while Dion is standing right in front of them. So that's what they do. Because of that, that's the reason why you need to have a most recent photo of the person in the foreign country, so that the sheriff of the county, wherever he is, will have a picture to show and see, oh, okay, I know who I'm looking for over here. So even if he comes and say that it is not him, then obviously there is a photo that will verify this is how he looks. He's got a scar over here, he's got one eye, or whatever the case might be, but they will be able to find him in that country wherever he is. So the photo is very important. So your deposition affidavit with those annexures, the annexures is in your notes. All of those annexures must be in there. And that all of those documentation will then go to the country wherever the case is going to be then heard. Now you've got your recent photo. There's a thing in the policy document how these documents should be certified. And it is quite different from how we just put a certification and say gecertificeerd of ware afskrif van die oorspronklike certified, a total copy of the original, the way we do it. But the way they want us to do it whenever you deal with any of the foreign countries is on page 26 of the notes. Certified a total copy of the grounds upon which the making of the order might have been opposed. That's one example that you can see on page 26. And whenever these documents are certified, there is a specific format that needs to be followed, similar to page 26. The other one is on page 20. So page 20, on the back of each of your documents, even the deposition affidavit must have these words on it, that this is the photograph or certified photocopy of other documents as the case may be of the case, and then the magistrate must certify each and every of those documentations. I'm showing you page 20 specifically because the UK has got no problem, the Crown Prince has got no problem to send these documents back to South Africa because it didn't comply with page 20. Each and every of those documents must be certified by the magistrate, and it must be certified properly. And if it is not, the Crown Prince in the UK, I'm making an example of the UK because I've worked with it and I've seen what they do. They don't care. One document or one court order, whenever a provisional order is made in South Africa, it takes nothing less than 3 to 6 months to get to that country. And it's going to take another 3 to 6 months back in case there is something wrong and the documents are not certified properly. And that's why I'm telling you this. Make sure that it's properly certified, because if it's not, it's going to take another 6 months back. And you do not have time to waste like that. And I always make an example, and I'm going to make it again, and I'm very religious. I'm not saying this in any way, this showing discontent towards any religious group. But the most perfect human being on earth, Jesus Christ, couldn't survive 40 days without food. How do you expect a child to go and wait 3 months for this document to go from the court to the Department of Justice in Pretoria, International Legal Relations? That's where it goes. From there, it goes to an organization called DIRCO. That's the Department of International Relations and Cooperation. Then it goes there. And from DIRCO, then it only goes to the consulate or the country, the South African embassy or South African consulate in that specific country. From there, it goes to the court. From the court, then it goes to the sheriff or the county, and from there, it goes there. It's a long and tedious process that it takes there. By that time, Jesus would have been dead, but they expect this child to be in such a way that this child is going to survive on a confirmatory order that is not confirmed in the other court yet. So that means for a period of 3 months, 90 days, up till 66 months, 180 days, it can take one order, one confirmatory order to get to its destination in the foreign country for the sheriff to serve it on that. No human being or no child will ever survive that. So the activists amongst us, if there's one thing that needs to be amended to start off with, it is the international legislation. That act is Act 80 of 1963. It have never been amended over the last 100 years. All of us, none of us are that age over here, maybe Laurie, but some of us over here are not close to that age. Your birth. Okay, at least there's still people surviving today on this piece of legislation that's still existing today. So the point I'm trying to make is, please, we need to get activist Pearl Welsh and her team, Advocate Yasmina Mohammed, we need to get this piece of legislation to be amended, because we cannot wait so long for a confirmatory order to go all the way to a reciprocating country over 3 to 6 months. No human being, no child can survive. Section 10(6) of the Maintenance Act says we must expeditiously, we must limit the amount of remands and the postponement dates. How can you postpone a case for 3 months? Or it's not even postponed. The confirmatory order is made. Once the confirmatory order is made, it goes its way to DIRCO and to all of those places to get to that country. If there's a mistake on that form, like what I said on page 20, and it's not being certified properly, it goes back the other way again. So to avoid that, we need to change this piece of legislation so that we can send an email to the Crown Prince, that we can send an email and tell them, because the UK government is speaking directly now to us, because I've got a case the 27th of January that I'll be dealing with, where the UK directly contacted me and said, listen, we need to get this thing sorted out. So why can't South Africa do the same in a case where we're dealing with it? The SA Law Commission is introduced an amendment paper 157 in May this year, May 2022. In terms of that paper, there's going to be some fundamental changes to the maintenance legislation. There's going to be a lot of changes. One thing that is missing is international maintenance. And that is what we need to do. I did discuss it, and my wife, we did try to get it onto the law commission. Our lawyer also was over there to discuss specifically changing the REMO legislation to accommodate these type of cases that I'm referring to. We cannot wait so long. If it's not going to be done, then we're going to struggle with. Unfortunately, the law commission felt that this is what we are dealing with now. The chapters, that document is already so thick. It's 157 pages. There's no more that we could have dealt with it. But there's nothing that stops us from getting to the Justice Portfolio Committee and inform the Justice Portfolio Committee, listen, there's a piece of legislation that's older than all of you parliamentarians sitting here. We need to get this piece of legislation changed. We cannot go on like this. Otherwise, there are women that's going to be suffering even more. They're going to change Regulation 26 of the Maintenance Act that says that except for faxes, we can email the respondent and we can do all of that. The Maintenance Amendment Act also says we can act now faster and speedily. But that's the only pieces that they're going to change, Regulation 26, that except for sending it via fax, you can maybe send it via email in future and all of it. But the international legislation, nobody's touching it. So hopefully the online viewers or people that are listening to this today will be able to somehow take it further. And the first point of entry is the Justice Portfolio Committee. We need to tell the Justice Portfolio Committee, parliamentarians, there's a piece of legislation that is old and archaic as day itself. Please help us to change this, because if we're not going to change it, people are going to keep on suffering. Okay, so now you've got your maintenance legislation, your deposition affidavit in place, you've got your Annexure V, you've got your Annexure W, you've got your Annexure Y, all of those pieces there. Then, and you are now approaching the court. When you get to the court, then the act says you can either do it in a writing or viva voce evidence, or you can go and speak. if you have your deposition affidavit there, your deposition affidavit can just be read into the record, or the magistrate will call you, Liesel Cronje, are you Liesel Cronje? I confirm I'm Liesel Cronje. Is this your deposition affidavit? Yes, it's my deposition affidavit. You confirm the truth and the contents, and there it's done. It's not necessary for a long winding thing where she have to be going through all of it, because the deposition affidavit is certified and it is there. She just need to confirm the truth and the contents of the document. Once you've done that, there's no thing. Most times, the maintenance staff in South Africa is going to say, no, we had a trial date and all of that nonsense. It's not necessary. If the deposition affidavit and that bundle is completed properly, with an index, here's my photo, here's the children's birth certificate, here's the account that he used to send in, or this is the account I want him to send in, here's my correspondence with him, he knows he's got a responsibility towards the children, here's his Gmail address, here's his photos. What more is needed? Nothing more. So once all of that is in there, then the court can, in chambers, certify that documents and say that I accept all of these evidence, I make an interim order. Once the interim order is made, 4 sets of copies must go to the Department of Justice's International Legal Relations Unit. There's a person, if you go on onto the Justice website, on www.justice.gov.za, on it, when you look for international maintenance, they'll tell you that you can speak to a lady called Mary Ann Wilson. Miss Mary Ann Wilson have been there for ages. She knows the act better than any of us. She will be able to guide the process. M. Wilson at justice.gov.za. She's going to hang me after this, but it's fine. But Ms. Mary Ann Wilson is the person that deals with it at the Department of Justice's International Legal Relations. 4 sets of copies will go to Ms. Mary Ann Wilson, being sent by a registered mail from the court to Department of Justice in Pretoria. That 4 sets of copies will then go to DIRCO, Department of International Relations and Cooperation. DIRCO will send it then to wherever the person is finding, to the consulate, the South African consulate. The South African consulate will send it to the court, and the court will then send a copy to the sheriff, go and serve this on this person, and then the person will then appear in front of court, and then he will then either give his grounds for opposing and say, I'm not the father, I don't know who they are talking about, whatever it is. If that happens, then a trial starts. In the reciprocating country, they do the trial, and then all of that information is relayed back to South Africa and say, this is what he's going to say. Now call the lady and speak and find out what she's now saying. Then she will make up a supplementary affidavit, or all of those things can happen. But I'm dealing with a case now that is going to completely change it, where I'm going to be sitting the 27th of January in a hearing in the UK, where the judges I will see the judges via audio-visual link, and it can be done. The Criminal Procedure Amendment Act 12 of 2021 says audio-visual links can be done in any matter except a criminal matter. So why don't we use this for these type of maintenance matters? Why are we still stuck in the archaic way of dealing with these cases? While the Amendment Act 12 of 2021 says you can use an audio-visual link. You can sit at Saartjie Baartman where you're comfortable and where you feel safe and secure. Or you can sit in your attorney's office. I dealt with a case. I can show it if there's cases that I've dealt with audio-visual links where the attorney and a client is sitting in one room, and I'm sitting at the DPP's office, at my office, and I've got an audio-visual MS Teams link. And we do the same as what we will be doing, instead of dragging these people all the way from Limpopo over here, and then we have to pay Section 11(2), subsistence and travel allowance, plane tickets, accommodation, and all of those expenses can be circumvented just by our audio-visual link. Section 51C of the Criminal Law Amendment Act 12 of 2021 makes it clear we can do it already. We don't have to wait. If the lady is suffering from being abused and she can't speak in front of him, why can't we get a guardian, intermediary to assist her in terms of Section 51 to lead the evidence? All of these things have been made possible within this year that we can use in order to lead that evidence. So that is where we need to go with it. Coming back to international maintenance, so this is how it can be relayed quicker. If we have a contact person on the other side, and the UK and South Africa is having that contact now, we need to establish that contact with other countries in order to speed up these processes. But the only way we're going to do it is if Parliament somehow say, whoa, we need to come and deal with that too. If we're not going to get Parliament's buy-in, then unfortunately we're going to be stuck where we are for the last 50 years, and we're not going to go anywhere. So the activists online as well as the activists out there, please, if you can help us mothers and those activists that want to somehow take it further, please let us get to the Department of Justice, let us get to Parliament and inform the parliamentarians. There's an archaic piece of legislation called the REMO Act, the Reciprocal Enforcement of Maintenance Orders Act 80 of 1963, and the REMO Act, the Reciprocal Enforcement of Maintenance Orders Act 6 of 1989. Both these pieces of legislation is so old and worn out that we need to get it updated or in an electronic format that works with the Industrial Revolution. If we're not going to get that right now, that we're going to be stuck there for another 5 to 10 years before the Law Commission wakes up and then say, okay, no, we need to deal with it. All respect to the Law Commission, 2011, the Maintenance Amendment Act was asked to be amended by the minister. 2011. It took 11 years for us to get to the paper 157 that is now at the Law Commission being discussed. It took 11 years for maintenance legislation to get there. It's going to take another 11 years before we're going to get the international maintenance legislation to be put in place. We cannot wait so long. So if I can make an urgent appeal to the activists, please let us get to Parliament and let us lobby those politicians that is going to ask now for our help, for their votes next year. So before it gets there, and you ask them, what are you doing about the international legislation? Come, let me quickly explain to you. So you make it worth the vote that you give them to make sure that we get these pieces of legislation sorted out. Okay, so the lady's got now a provisional order in place, went there, now she sits and wait, and she's going to wait, and she's going to wait. And that's how it's going to go on unless somebody do something about it. As soon as an interim order is being made at the court, that is when the magistrate becomes Functus Officio. Functus Officio, a Latin word from the old times saying that I'm done now. I'm crossing now my hands. I've got nothing more to say about it. Unfortunately, the maintenance staff do the same. They are also now Functus Officio. They are also Functus Officio. The magistrate said there's Functus Officio, so everyone is Functus Officio. But what about that lady? Somebody needs to follow up. Somebody needs to do something. If you ask any maintenance court in South Africa, they're going to tell you, no, we've got a registered mail number, the registered mail, we did send it to Pretoria. You must call Pretoria. Who in Pretoria? I don't know who, just call Pretoria. If you call Pretoria and you don't know who you're speaking to, you're going to go nowhere over there. You need to know who are the person on the other side that you need to speak to. Even there, they will tell you, no, we sent it to Darko. Don't know what happened after that. And that is the problem. There's no communication between government departments pertaining to these processes. And that is what we need to somehow make clear to the politicians and to people out there, that they need to look at these things to make it possible. One lady in Bellville, she had to follow up herself in her own case. She had to appoint an attorney in order for the attorney to contact the UK in order to get this ball rolling after 6 months of no communication between anyone. So that is what's happening to the system. If the lady thinks, no, I sent it to Namibia. Let me make this example. In Kuilsrivier, there was a case that went to Namibia. A donkey with Jesus on it could get there quicker to Windhoek than what it took in order to get that piece of document to Windhoek. What I'm saying to you is this is serious. Nobody is following up on these type of cases whenever it goes to the court system. Once it is done, then it is done. And all I'm asking is, please, don't let the donkey take the thing to Windhoek because it's never going to get there. there needs to be an easier way that we can communicate with our foreign or our sisters in Namibia, Zambia, or any of these countries. We cannot go on the way it is. That just if he's staying in Namibia, okay, no Koekenaap is not in Namibia, Quinton, and it's all right. But somewhere over there, and from there onwards, then you deal with the specific case in that specific court, and then there will be the access. Then the court in the foreign country can confirm the order, or they can make a new order, or they can amend the order. So that provisional order can still be amended. So don't think if the court says you can get now 1,200, you're going to get 1,200. The court in the other country can always amend it or confirm it, or they can change it to whatever amount, or they don't even have to make an order. Then they'll send it back to you and say that, listen, we didn't make an order, or whatever the case might be. That is the process that is followed when you deal with the case where it started off in South Africa. Quickly, the other way around, I know my time is up, but if a case is from the other country, the lady is living in the UK and she sends it to South Africa, and the respondent is living in South Africa, then the process is going to be where it goes from the UK to Pretoria. From Pretoria, it will go to the court closest to where the respondent is staying, and then where the respondent is staying, they will then summon him to court. The DOJ Code 26 of 2015 says what the clerks must do. The clerks must immediately register that case, because the moment it is registered, that confirmatory order, then it becomes alive. Then he can then deal, or then he can be held liable for whatever from that moment when it is served on him. What sometimes happens is some of the staff in South Africa don't know how to deal with it. And they see this document, oh, okay, now it's lying. Then they leave it over there in the desk. And somehow it gets lost in translation or forgotten. Or, and they just pile it and another pile of it. Number one, immediate registration should be done instantaneously the moment they get it there. The maintenance investigator must serve it on that person. Papaki, there's a confirmatory order from the UK or from Russia or wherever, Kyrgyzstan, and you need to pay this amount from now on. He can come with whatever excuses or say, ek kan nie bekostig nie, or whatever. Mr. Quinton Zimmerman told us that you're not going to come with that excuse, that there's over-indebtedness, it's reckless. We cancel that. You're going to pay what you're supposed to pay. That's what we're going to do from now on, and make sure that we hold them accountable for whatever they are saying. So the order is coming from the other country, it's coming to South Africa. The Department of Justice court officials will register it. Once the orders are registered, then it is served on him. He can come to court with whatever excuse and say, nee, maar ek kan dit nie bekostig nie, or whatever the case might be, then we will deal with him there. The court in a similar fashion can either confirm the order or they can amend the order based on whatever his means is, and then deal with it in terms of the maintenance legislation in South Africa. Once that order is confirmed, it is sent back to the country wherever he comes from, and then we deal with it like that. The UK have a thing where when the child turns 17, then the order is suspended. I dealt with a case in Somerset West where whenever a child in the UK gets the age of 17, then that order is suspended. Why, I don't know. Luckily for me, in this specific case, the lady in the foreign country heard about what we're doing in the Western Cape. She contacted me, and then I went to the Somerset West Court, and I asked that the order be extended. Called the respondent in and told the respondent, South Africa, a child's a child until the age of 18. In terms of Section 17 of the Children's Act, therefore, you're going to still pay, even though they want to suspend it on that side. Then I sent a document to the UK in which I said, no, South African law, in terms of our Section 28, the Constitution, the rights of children are being upheld to the best of their interest, and therefore the court order will still be valid in South Africa. The gentleman in Somerset West, he's still paying despite the UK wanting to cancel the court order. So if there are any of these type of cases that you are aware of people overseas where the orders were suspended, we can revive the order. Z versus Z, that my wife did in August, September, said specifically a child doesn't miraculously become an adult at the age of 18. In terms of Z versus Z, you can up to 23 and 25 years, you can still claim. There's a case in Georgia that was decided last month. Judge Saldana said, even if they are 23 or 25 or whatever the case might be, in the maintenance courts, we will still deal with that maintenance case. So even if the divorce order says that up until the child becomes 18 or self-sufficient, whichever comes first, and they stop paying the second the child is turning 18, we can still hold them liable. The same in the UK. 17, they stop the order. We need to make sure that we enforce those orders against respondents that is in South Africa and that would like to then get that information. I've got more information on the handout. I didn't go according to the handout. I saw poor Nell. I said she must just type out, just enter. What is going on? I'm sorry, Nell. I am like that whenever I take the stage. I'm worse than Quentin Zimmerman when I get over here. So luckily, you got most of the information. So before Pearl Wells chase me away, I will be in the cafeteria. If any of you want information, please do. Mr. Fabian Daniels only got one order so far. Please order and support him. Otherwise, we're going to have a lot of wasteful expenditure on his side, and then he will have to throw all that food away. So please assist, even those that are leaving a little bit early, please assist him. Thank you.
Thank you, Advocate Ratus. I would like to answer your UK question. I have two daughters. They've got British passports, even though they're South African citizens. But because they moved to the UK, my daughter at the age of 16 was classed as adult. So then the rights of the parents falls away. So this is where your discrepancy came in. So it depends on the jurisdiction of whether the child was actually in the UK or in South Africa. That changes the moment depending on the passport, even if it has dual rights. Yeah. So, yeah, well, I am the victim of a number of issues: maintenance, divorce, and estates. So I can speak on behalf of a number of those: international law, South African law, with my own personal experience. I think I'm going to take my little presentation, which is on safety and security, maybe by heart, because the reason I started this and becoming an activist on gender-based violence, looking at how we can reinforce and getting the government to support prioritizing child maintenance, interim maintenance, and eliminating the abuse of interdicts amongst parents, is because I've not had the abuse. I've had the maintenance issue. I've had the fraudulence of trustees in other countries, looking at international law, looking at South African law. And that is my experience that I can contribute towards all the other women that is going through all the maintenance and abuse right now, not knowing what to do with the court orders. Everything Advocate Ratus have mentioned now, I've been through, whether it was child maintenance 20 years ago when I got divorced and my ex-husband left, didn't support us. I had to try and enforce this through another country. He was working from one country to the next, and it was difficult for those officials within the government to actually execute what they had to do. I physically walked the process, been there, done that, and got this whole process through Interpol. Interpol still didn't enforce, whether it was my divorce maintenance, whether it was my child maintenance. We have a huge problem within the system. For me, it is very difficult for most women, some of them that doesn't have the financial means, to try and enforce, working with embassies, working with DIRCO, and seeing how not only emotionally that you're going through the stress, you're going financially through the stress. You don't have the financial support. You've got to go out there, work. You've got to be able to take care of your children, educate them, and give them a basic sense of values and ethics as to what they're supposed to stand for in a basic family life. It's very challenging. I've actually myself approached the Minister of Justice advisor, and he called me back a week ago. I've basically made a negotiation deal, not because of politics. I said to him, Mr. Advisor, I can't pronounce his name. It's a little bit difficult, like Mrs. Jilingizi. So I will just refer to him as general, as the Mr. and advisor to the minister. he basically came back to me. He said to me, I will get you somebody from Parliament to see, as long as we do not upset the apple cart. And my view to him was, we don't have to reinvent the wheel. Everything that is already part of the Constitution, that's already written down, has to be prioritized and enforced so that we do not have to go through the delay of time constraints, that we do not have to spend 10 years trying to go through a divorce, which is one of the women from the maintenance group. I saw yesterday where we tried to then, we support one another. Advocate Raters included me into this group. I find it's a total shame, the waste of time that we have to go through for the people on the other side of justice that has to make the decision for what is already implemented and executed. I don't see why the system is backlogged like it is, that the maintenance is not prioritized the way it should be. Oops, I don't know. Okay, so we're just going off by heart. As far as coming back to the foreign enforcement and child maintenance is concerned, whether it's interim maintenance or even if you have life partners, between South Africa and Switzerland, I've discovered the last 2 years that I've been working on my own personal matter. We do have a lot of treaties between South Africa and Europe. We have the Hague Convention. We have foreign enforcement. For those people that don't understand, yes, the courts have made it easier for us now to serve via email, and they've accepted that. So it eliminates the time constraints, whether you have to go to the sheriff's office for the sheriff to deliver, depending on the backlog of what the sheriff has got to deliver. And by the time the service return comes back, for all those delays, for most women that's going through emergencies, and if you have children, some of the children being disabled, that you have to actually take care of them. Sorry, my throat is a bit crackly today, so you will have to excuse me. I have to drink in between. For the foreign enforcement of judgments, you can now, we have agreements, as long as you also able to translate those agreements into the languages. It depends if it's Germany, if it's Austria, Switzerland. Obviously, England being on the British law, similar system to what we are functioning on. English is English, so it makes it easier, but yes, it is much more convenient for us to have now the audio visuals where we can, thank God for COVID. COVID has forced us basically that we are able to find different solutions to function and do business, and that has enabled us to communicate much better, even on the legal system between countries. So that has made it much easier for us to be able to sit in our country, not having to accumulate all the additional traveling expenses, hotels, flights, which most of our women and children that is suffering, and even from the less fortunate areas, they don't have this kind of money to be able to fight the justice system. Then we get to the justice system, where we have a lot of unfair justice, the unjust within the legal system amongst lawyers, advocates, and judges, where they tend to prejudice most people because it's all about where the money comes from. And this is very unfortunate for the people, or for our communities, having to go through this, not knowing where offered me for the following week to see how they can come. And maybe it might not take us another 10 years, it might not take us another 11 years. I hope I have the support of all of you, that you will support me in standing so that we can push for the amendments to happen within the Maintenance Act. Now, I would like to introduce you to Yasmin Mohammed. I would like her to come and put her presentation on struggles of women and never giving up, because that's what I have done for the last 20 years.
Thank you, Paul. Let's see who's awake. Good morning, everyone. Good morning. Good morning, everyone. Good morning. Okay, so you are awake at this time. So I am Advocate Yasmin Mohammed. I am a member of the South African Bar Association. I litigate in the High Court and the Magistrates Court. I also mediate. So today I would like to talk about the struggles of women in our society and never giving up. And this is very close to me because I am someone who has endured something like this as well. I didn't really prepare much today because I had a very, very hectic week. I was actually in court the whole week and I'm exhausted. But you know what? I'm going to speak from my heart to you and tell you what I really feel about this topic. I've been meaning to do this for a while, and Dion and me have been liaising, but it's just never come to fruition until today. So my thoughts are that, you know what, women empowerment has been an immense topic that has been taking place over the decades. But what have we done to make things happen today? What are women going through today? Anyone have any idea? Anyone want to say anything to me? What do you hear mostly in the media or in the public or someone going to court? What is women going through?
The most.
So, okay, I have made a few notes. I'm not going to be discussing the law today, but I will be discussing a few things. So the kinds of abuse that women deal with, or rather the kinds of immense problems that women face, is sexual harassment, abuse, discrimination, teenage pregnancy, gender-based violence, unemployment, HIV/AIDS, poverty, rape, and many other things. And something that has come really, one of the cases that I've been dealing with recently, which has caused a lot of problems dealing with this, is where women, mostly women, have been dismissed, fired from their jobs because they refused to take the COVID vaccine. This is one of the cases that I'm currently working on for a few months now. And it's a really, really big case that's going to be, precedented. But I do not want to talk about that today. So what I will say is Section 9 of the Constitution is equality. And our Constitution says that every woman has a right. But you know, a lot of women don't use their rights because they don't know about it. And in the next section, I will be discussing things about what we as women should use and use to protect ourselves and use to, update yourselves on that sort of thing. So what is Section 9 of the Constitution? Section 9 of the Constitution says, women are protected by rights guaranteed in terms of the Constitution, and namely, its right to life, right to dignity, right to privacy, and many other things. So the prohibition of discrimination on the grounds of gender, sex, pregnancy, marital status, it is all clearly intended for women. But do we use it? Do we know how to use it? What do we do? Many women go through a lot of issues and they don't know how to go about because they can't afford an attorney, they can't afford an advocate. They go for pro bono assistance. In the end, they don't get help because that pro bono list is long. You have to stand in a long, long queue. Sometimes many do affidavits. But then what happens? Your case is so legit, it's so strong, but it doesn't come forward. Why? Because your drafting is not done properly. And I understand that people can't pay for drafting. and you go to the police station and you do an affidavit, but yet your case still doesn't come out, it's because of what you averred in your affidavits. And many times that I've come across strong cases where, you know what, recently I've had at least 3 cases. One, a divorce, where a woman came to my chambers and she just started crying and crying and crying. And for us as women, we have to be strong for others. It's not always easy. Me too, I'm a woman. I wouldn't be here if it hadn't been for my struggles in life. But no, it's got nothing to do with marriage or abuse or anything. It's just that I've come from a long way to be here where I am today, because I lost both my parents and I had to build myself up to through the struggles to get here. But that being said, my client came to me and she was crying, and I asked her, like, what's going on? Because I'm busy with your divorce now. You seem to be quite okay. And she said to me, I can't handle this anymore. And she started crying, and I didn't know how to console her. Yet I had to be strong for her. And it was so difficult, and I couldn't show her that, you know what, inside I was actually crying. And I wanted to really just do something to you know, do something to tell that ex-husband or soon-to-be ex-husband of us that you are so wrong in what you're doing. So she experienced so much abuse from this guy. He wanted to take her property as well, and she has this child. But okay, a child is not from the husband. But that being said, it's very hard for a woman to have to deal with these kind of emotions and these kind of issues. And there's many females out there who is struggling in silence. You don't know what kind of impact you might make. And I hope that this talk is going to help someone out there that's going to reflect on something, and maybe you can make a difference in someone else's life by being there for them, by just supporting them. And just, you know, someone also recently came to me and was talking to me about going overseas, and I don't want to mention names, but yeah, she's going overseas, and she couldn't go because the ex-husband doesn't want to give her that authority to let the children go. And I told her what to do, and we were going to take a matter to High Court on an urgent basis last week, and she couldn't afford it. And you know, I said to her, you know what, just come to me, I want to talk to you. Because she was crying. She was trying to hold back, but I could see right through. I said, listen here, just come to me for coffee. I want to talk to you. And she wouldn't want to come because she was in a state. And I tried to be there for her. And you know what, my little bit I know helped, because she thanked me afterwards. And that's just one thing. The other thing is, we always talk about women, but what about men? Men struggle too. Men suffer too. I had another client that came to me recently where, this was actually in this week as well, where he was saying that, you know what, my wife doesn't want to give me a divorce. She's taking all the stuff out. And then they started sending me all these photos of how they dumped all these cars and his property and things outside in the street without informing the attorney. His attorney wasn't even informed. You can't do stuff like that. I mean, this is a woman doing this to a man now. We always talk about women getting abused, but what about men? We as women, we are strong, and we have to be strong. But are you being negligent to your husbands or your spouses? Ask yourself that, because men do suffer as well. And I am here today to give you this message that no matter what you're going through, whether you're a man or a woman, never give up. Never give up. You don't know what impact you're going to make on someone tomorrow. You don't know where that's going to lead. You're going to be here to teach your children and the future generations to stand up for your rights. And that is what I really want to tell you, because I didn't really prepare something. But yeah, I just want to say never, ever give up, because it's not only females struggling, it's men too. And we have to support men as well. So I strongly believe that we should start a platform to support men as well. And I've seen it recently with my client. And it was really, really bad and quite disappointing to see that a female did that to him. Anyways, I hope that assisted. If anyone needs any assistance or need to talk, you're most welcome to come to me afterwards, or come see me in my chambers at Mandela Roads. Thank you.
Thank you so much, Advocate Yasmin Mohammed. Ladies and gentlemen, we have to respect each other's rights without violating our rights. The part is that we have to start thinking of How do we stand together? How do we make a difference? How do we re-establish the values and ethics which we have lost within society amongst the corrupt world and politics that we live in? We are about to take a small break so that you can refresh and have a bit of energy. 10 to 15 minutes, if that is fine. Thank you very much. What time are you going to go? Are you staying? Are you staying? Because it's just two more presentations, and then I think you want to. No, that's fine. Not a problem. I just wanted to know this clearly because again with load shedding, didn't get the. Listen, even if you have the presentations, with all the presentations being done, what you want to say always changes. So it's just one of those things. We have a big problem with the system. We have the legal mafias that were in the system. It needs to slowly be eliminated because you have the different things. I'm working on that. The other day I saw a judge doing something totally out of the ordinary, which I always did when I was I'm in my own right, not in the legal right. I have some This is exactly what the judge came with. Yeah, but you see, this is the thing, even on urgent, they throw it out and they'll say it's not urgent, because it's not so urgent now.
talk about teenage pregnancies. And they are from the Department of Education. So they will say what they are doing as far as teenage pregnancies is concerned. Mr. Morgan is from the Department of Education, Safer Schools Project. So they will explain in more detail what they are involved in as far as that is concerned. So the technology is failing me over here. The laptop is not going on, so Mr. Morgan's going to probably stop. Sorry, Mr. Morgan. There's always something going on with the Jim Opperman is not here. But first, Ms. Anthony, to introduce Mr. Morgan.
Good afternoon, everybody. Thank you, Mr. Morgan. Thank you, Mr. Morgan, for supporting. I am a little nervous though, but I'm here and I'm going to do what I'm supposed to do. We are a group of people that came together and we called ourselves Learner Pregnancy Collaborative. And this was something so necessary in the townships. Because when I walk in the day hospital, every second person that I see at the MOU is a teenager. It is actually funny for the grown-ups to sit there because it has become the norm that it's teenagers sitting there. And one day as I was sitting in my office, opposite is the sonographer, one of the ladies was chatting and said to the other one, "Do you know the most dangerous place to be?" And she answered, "It's the womb of a mother." And to me, that was so shocking. When I sat there and thought about it, thinking of how easy it is for a teenager to come into the day hospital and say that I'm pregnant and I do not want this pregnancy. And if I think 5 years ago, it was mainly our grade 10s and grade 12s that would come in and we sorted them out. But now lately, we're having 13-year-olds coming in. Yeah. And so I know about one lady coming in with her daughter the first time, and I looked at them and I thought she's probably coming with a mom. But she's just coming with a school because she looked much older than somebody that's going to have a baby. But then I heard that that is the one that is coming for a scan because they need to determine how far along she is. I'm looking at this and I couldn't say anything because the mom is with. 2 months later, she's back. And the same thing, another termination of pregnancy. My question to us sitting here, I've been involved in lots of attempts of helping people with teenage pregnancy, and so far, my efforts has fallen, not my effort, the efforts that was being done in the community has just fallen flat. And to me, due to people pushing agendas as, am I going to look greater than you because I want to manage this thing? And I constantly say that I don't have an agenda because I work for the Department of Health. And my agenda is to see, even if it's just one girl, coming out of Bishop Laver's saying that I have made it, because that is my dream, seeing our girls becoming women that they themselves can be proud of. So we have formed this collaboration, myself, Mr. Morgan, and a group of health promoters. And then we also have a lady from the University of Stellenbosch who is busy doing a PhD. When I called on her, I asked her, this is what I want to do for the community. And she said, Priscilla, do you know what? I'm thinking about something now. I'm thinking, what is it that you really want to see happening? And I said, I need to see that moms communicating with their children, telling them, come to me if there's a problem. Don't come to the hospital with your peer, with a 12-year-old, you were 13 years old. 3 weeks down the line, everybody knows you were pregnant and you're being at the day hospital. And my dream is to see something tangible that we can give to the grade 7 learner that is going to the high school, a book. And she came up with this idea because at the moment, I think she came back on Friday evening from Belgium because she did part of the thesis she did there. And her idea was to create a book for teenagers where on the one side we are going to say what a learner wants to know or wants to know from a mom. And when you turn the book over, the book will say what a mom should tell a daughter. And I'm excited about this program. I know this is not going to fall flat this time because the group of people on our side, we do not have agendas. We only see the girls that is needing intervention. And so if anybody is sitting here, you might have been affected with teenage pregnancy because it doesn't just happen in the townships, it happens everywhere. It's just how we deal with stuff. Our people think just coming to a day hospital, getting the medication and that is the pregnancy. They don't think of the long-term scars and what they will feel like eventually. And so this is not just my job or the health promoter's job, but every mom sitting here. If you know about somebody that needs help, we need to jump in and we need to make our voices heard because these girls doesn't have a voice always. They live in houses where they are scared to go and sleep at night because the stepfather comes into the room. We had a situation in Heideveld, and Mr. Morgan can be witness of this, where one girl was recruiting girls for some studio, and it ended up that they were making movies, like porno or movies. And the guy gave her 500 rand and she gave 250 back because she said it was too much. And so I'm saying we need to be the voice for those girls that are out there that is, I don't know what happened because there's not just one reason why girls fall pregnant. That is what I learned. Not to just jump in there and have scare girls out of their wits and then see them back in 3 months' time sitting at the MOU. And I look at them and I ask him what happened. I just spoke to you 2 months ago. And this is what the one girl told me, don't you worry. It's got nothing to do with you. It's got everything to do with us and where we act and what's happening to us. So if you know in your world that this doesn't happen, I want you to be aware that it's happening. It's right. I think it was Elsa's River last year had 35 pregnancies in the creek. And it's getting younger all the time. So I just want you to know that is what we want to do. There's people here sitting that want to get involved. You are so welcome. We would really appreciate it. Thank you.
Thank you for honoring me for this opportunity. Now, because we collaborated, we came to an agreement that we must have a vision statement, a common vision statement. And our vision statement went like this: to promote self-awareness and prevention amongst our youth, which will lead to making informed choices and responsible lifestyle. Okay, this we also make a mission statement that is to strive to form a strong partnership with knowledgeable people. You understand? We cannot just get everybody in. Because as you heard, our objective was not a once-off awareness. We try to move this into a type of a preventative measure to really make an impact within the community itself. Now, okay, from my side, I am but doing most of the admin work because I can talk a lot about teenage pregnancy or whatever the cause. Okay, so this was our mission statement. Strive to form a strong partnership with knowledgeable people and community members to decrease teenage pregnancy, to create a positive mindset towards life, as well as to ensure more approachable parents, because our parents don't talk about this, especially not around stuff like this, about sex and sexuality and those type of things. Okay, we also strive to achieve a better generation for better tomorrow. From our side, teenage pregnancy seems to be the root cause of all our illnesses within the communities. Most of the kids that have disciplinary problems are single parent kids. Most of the kids that are involved in gang activities come from single parents. So So we try to chop that thing off before it even starts. Okay, so the aim of the program was to encourage our learners to make informed choices as we heard, abstain from risky sex behavior. You understand? Because of the target group, you understand, we rather preach abstinence. Apart from, we didn't really go for contraceptives and those type of things because we were listening to grade 7 learners, which are pre-teen and teenagers. They start with the teenagers. And create a positive mindset through their choices. Okay, so because we're collaborative, we must have input from our clients as well. What is it that you want to know? Okay, so we had a question and answer session with the learners as well. But okay, as our kids are not as well informed, okay, most of them really all they want to know is around the active sex activities. And that is what they. So we set up both boxes in the classrooms where they can put anonymously questions relating to pregnancy and whatever. Now, what specific goals that we hope to want to achieve? One is decrease teenage pregnancy. Another thing is when the kids are pregnant, they drop out. Okay, encourage responsible choices, create more confidence, youth, sense of belonging, alleviate poverty. Now, another thing about unwanted children in teenage, it is actually one of the root causes of poverty as well. So, this is part of our strive to alleviate poverty. Fight unemployment and decrease teenage abortion and children. Okay, so what activities could we or can we feasibly and reasonably do? From the Department of Health, and that is a full group of ladies that I'm working with because they are well versed, they are mature, you understand, and they did stuff like puberty and the stages of puberty. Okay, reproductive health, personal hygiene, mental health. We try to move this project as holistic as we could. You understand, from different aspects, social aspect, economic aspect, all of those type of different aspects. From the Department of Education, we could, from outside, we tried to facilitate gender-based violence, substance abuse, and different type of life skills. All of these stuff, which are also leading to teenage pregnancy, like gender-based violence, bullying, all of those stuff. And it can lead to sexual activity where the kids are actually leading to having sexual relations. So we try to approach it from different angles. This whole thing. Okay, so how did we implement it? As I said, first it went into personal development. Who am I? This is more or less also exercising affirmation. You understand? I am not just a name. I have a dream, a vision, I have skills, and this is the road that I want to take to become something in life. Okay, that's it. And then how do I work with the team? Teamwork. You understand? What is the name of the team? What is our value, so that we touch on the issues as such as values as well. Team song and dance. This is just to open up the kids, to break the ice, understand, because whatever we do, we always try to be as interactive with our kids as possible. But not all of our kids are extroverted. Do you understand? So we try to pull out some of those introverts and also get them to participate better with what they do. Okay, then we went further on the questions and which was in the classes. We separated the boys and the girls, and we spoke about puberty, such as body growth, sexual characteristics, fertility, virginity, and abstaining from premarital sex. Okay, it might not be both or whatever, but I mean that is the line we put. The reason why, as we said, that we targeted grade 7 learners. You understand that? We cannot, because if they know that there is contraceptives available, there are contraceptives, they understand they will start to experiment with these type of things because they will feel that they are protected.
Can I ask you a question?
Okay.
Part of this protection, when governments made sex legal for 12-year-olds, how do we actually fight this battle, especially against gender-based violence? I know that's a question, but governments made sex illegal from the age of 12, and this is part of the problem. And a few years ago, what you're doing now is exactly what I thought. How do we educate pregnancies from a young age? Is by teaching them how to use contraceptives from an earlier age. But I think we've got to go back to the core of, and it starts with government, having made sex legal from the age of 12. And for me, I don't want now the toilets at the school are being changed to unisex. I've got an 8-year-old son, and I don't want them to be mixed up. Rather keep those toilets separate, like we have done for the past few decades. I understand all these questions, but how can your organization go back to government and see how they can change? Because children at the age of 12 don't understand what sex is. They're still innocent.
Yes.
Okay, actually we are representatives of government. You understand? If they push a policy, we must just abide by the policy.
Yeah, but we as the people, we as
And
parents.
that is from outside. But prior to do everything that we did here, we outlined everything to our parents, and we got permission to talk to the kids about sex, reproduction, and all of those stuff. We even went as far as to get permission to take photos and everything from the parents.
I'm all in favor of that, but the core starts with government having legalized sex at the age of 12 when the children doesn't know anything about. They're innocent, the bodies are not even developed to the point yet.
Okay, can I get back to that?
Not a problem. I
Because,
just while we discuss.
you know, at my age, my mind. Okay, so now we do understand that is why I emphasize abstinence. Because I spoke to Dr. Roshana Kim, and she's our chief social worker, and I spoke about this project. And they understand, and she said it must be age appropriate, you understand? So because we deal with primary school kids, we will preach abstinence. If we spoke to high school kids, you understand? And the high school, even the high school, they don't want the nurses to come into and give the girls contraceptives and stuff like that, you understand? Because it would also promote what you see, sex in the toilets, you understand? And once they cross that barrier, or that line, you understand, it will create a discipline problem at the school because I'm an adult now. Who are you to tell me what to do?
Not only that, the contraceptive would interfere with the hormones of the kids at that age.
So, but the principals are well aware, you understand, they are the custodians of the schools, so they won't let this type of thing into the schools unnecessarily, irrespective of what, because the schools are also governed by the SGB. You understand? So whatever the school governing body decides relating to something, because we will get more liberal schools which will adopt this type of thing. You understand? But in the areas that we live and work in the high-risk areas, and those people still have a bit conservative values around, especially the teachers around teenage pregnancy.
I just want to say, besides being an activist, we are doing behavior modification at primary schools. And the worst part is that a child at 11 is sexually active because we move sexual education out of schools. So for me, the governing bodies has lost its plot because they're supposed to speak as earlier alluded. The Department of Education with your governing body or the school management with the governing body, there's amendments to legislation. Why are they not actively involved in the amendments of the legislation? Because we can't allow a child of 12 years old to have their right. And I understand where it comes from. We are doing missing children searches for missing children in Mitchell's Plain. And the runaways, specifically girls that are running away, and you find them with gangs and being sexually active. And when they come to court, they say that it's consensual sex. Now, in my mind, that's not consensual because it's a minor, personally. The court is not supposed even to throw that case out because it should be statutory rape as far as I'm concerned, but it's not happening in our community. So for us, the voice of the community is very important in making sure that legislation are being amended to suit the needs of the community. We've moved from COVID, so there's a lot of things that change.
Okay, I do agree with that, but before I give my colleague a chance to answer, he's more acquainted to the policies. First of all, people concentrate too much on doing the stuff at schools instead of doing it within the communities, to understand? Because the kids come with that into the schools. The schools are there only to deliver a curriculum. Only to deliver a curriculum. Not to deal with social. The Department of Social Development is there, or the community safety. They are there to deal with the community issues outside the school. Okay, what we are trying to do now, okay, we do it one school at a time. We set up the framework for what we do, you understand, in order for it to spread it further into other schools. But as I said, that is why we are collaborating. Each one should do their stuff. Like Department of Social Development should also accept here, you understand? Because out of school, it is a responsibility of the Department of Social Development to deal with those types of issues.
How many more slides here?
Sorry?
How many more slides here? Can you keep your questions for later?
Yes,
We're not
okay.
going to finish.
Okay, then we also, okay, so as I said, we also dealt with STIs and STDs and HIV and HPV and all of those type of things. You understand? Because we actually want to scare the kids. That is our objective. You understand? Of unwanted, we call unwanted sex, economic and social consequences of having a baby, an early baby. How does it affect your health, your young body as a young child? You understand? All the machinery, whatever, might be a bit damaged afterwards. And the importance of your relationship with your future husband. If he knew that you were sexually active and very active as well, you understand? There will always be the doubts and stuff that goes with it. Okay, that is the type of conversation that we have. And I must tell you that we even brought in the imams and the pastors in this initiative to do it from the religious side. You understand what we call it, what does the Holy Bible say regarding that? What is the values, the religious values regarding to sex before marriage and promiscuity and all of those type of things. Then we did the substance abuse and pregnancy. We discussed, you understand, how you lose your inhibition if you start use drugs and those type of things. Okay, so with the pastors, they spoke about the values, living a good life, spiritual connection with your God, the power of prayer, all of this, irrespective, even this stuff are policy. Do you understand what I mean? Okay. So, okay, and then we also needed, because policy tells us we need to include gender-based violence. So we included gender-based violence because we know about the grooming and stuff that happens within the homes itself, the familial violence that are taking. So we incorporated all of this. As I said, we wanted to do our holistic approach, but we cannot only speak about it. We must give them the support structures. Okay, if this happened to you, can you call this organization or whatever? If you like, for with us, if you have any problem, school related now, you can call our call center 0800 45 46 47. That deal with any problem. We do have social workers, we do have psychologists, we do have people that work with kids and that, but so we have all those. We also deal with, we have people, experts that can deal with bullying and stuff. If we don't have it, we come to you to ask you to come and assist us with dealing with the kids. Because we feel that the Department of Education cannot do it alone. We need all the help that we can get. That is why when the Department of Health asks us for our assistance, we jump at it. You understand? So we spoke about informed choices, career choices, relationship choices, abstentions, all of these stuff. And we highlighted especially the bad consequences. But at the end of the day, we're not holistic enough. We still have space because I didn't speak anything about the legal aspect of what we are dealing with. You understand how does a legal people, how does a social worker, that is just a couple of gaps that are still within this, within the structure. And as Priscilla just said, that okay, we take people on board that want to be on board. We cannot make them please. You understand? If as the time go on and they want to come on board, we are open for everybody. Thank you very much.
One question, it seems that you're very focused on females and women and victims. Do you also do policies for perpetrators and the men and focusing on educating them?
As I said, we normally split up the girls and the boys, but we want to do them as a collective now on the next project. So as I said, they are still open for organizations. We do one school, all the grade 7s, for a period of 3 months. So we try to cover all of the subjects within that 3 months.
But it sounds like you're just trying to focus on the women, the girls, and their role, and not push it to the men's responsibility.
I will give an opportunity for people to ask all of these questions, otherwise we're not going to finish. Thank you, Mr. Morgan. I really appreciate it. Thank you, Priscilla Anthony, for your presentation. We've got 2 more that we need to deal with. I first want to give Natalie an opportunity.
Who's the other person?
Sorry?
Who's
No,
talking?
it's Eugene's friend
Oh.
talk that I need to do. So I will quickly give over to Natalie. She will do a presentation on the mediation as a tool of healing society. So over to you, Natalie.
Mine is called Mediation and December Folder. Mediation as a tool to bring about collective healing. Good afternoon, everyone. It's lovely to be here with all of you today, especially that we acknowledge this is our last community dialogue for the year. It's been a long year. There's been a lot of commitment that has gone into this platform and this workshop. So I'd just like to thank everyone that has been committed to it, both online and present and here in the auditorium. And yeah, just thank you to all the people that have had their hands on the ground, kind of like putting all of this together. So I'm Natalie. I am a mediator. I do court-referred mediations and I do private mediations in private practice. But I really want to talk about mediation in gender-based violence, because I do mediations in the domestic violence court and children's court at one court. My heart is really around community and family and restoring families, because when we look at community, we see that the micro cell is the family. And when we have healthy families, we have healthy communities. So that's going to be my talk today. As I was thinking about how to kind of like launch into this, I read a quote by Steve Biko. Steve, can you just change the slides, please? And he said, innovation is part of the natural development of any culture. A culture is essentially society's composite answer to the very problems of life. We're experiencing new problems every day, and whatever we do adds to the richness of our cultural heritage, as long as it has the human at its center. Now, I think when I look back at the last year, or maybe the last 2 years when these dialogues kind of happened, we see that this platform has been this for many and in various capacities and contexts. I remember sitting in one of these dialogues, seeing the pain, the hurt, the brokenness in mothers, and a young guy who shared his story. And he spoke about how, wasn't a mediator, there was someone that kind of like, I can't remember the full story who did it, but it sent me down this path to become a mediator, just really to evolve into the bigger work that I do. And when we look at the community dialogues, we have seen that it always had the child at its center. And I know that next year, as the dialogues evolve, we will be looking at gender-based violence, because it is so broad, and we know that this space is, that we need a bigger space to fight all the issues of gender-based violence. And remembering to put humanity at the center of it all. So, I hope that my talk will encourage us to change the culture that we know, evolve into a culture that brings about healing, peace, love for our nature, for our nation, and for our generations to come. And the truth of the matter is, this change is going to start with us. To start with us, evolving from the culture that we know and that we were raised up with. And by doing this, we stop the perpetual cycle of gender-based trauma and generational trauma, which often leads to the social ills of society that we see today. And what I do know is that through honest conversations that we have here, and we have in mediation or counseling or whatever therapy you choose to start your journey on, we begin innovating processes that help our communities, ourselves, and the justice system to create a culture that is valued and one that we can pass on to our generations to come. And so I'm pondering Steve Biko's words. I couldn't help but think that much of the gender-based violence is because of a lack of healthy and stable families. The definition of gender-based violence is so broad, and there are various facets of gender-based violence, which are so intertwined, and we really cannot separate one from the other. I am a firm believer that many social ills we find today are a result of lack of healthy communities. And like I mentioned earlier, when we look at community, the cell and the microcell of community is families. And we are seeing now more than ever a breakdown of families, lack of fathers in the homes, lack of present parenting in our homes. And all of this is really resulting in a lot of the social ills we see today. So if we are all to be honest today, we are also part of the problem and contributing to some form of gender-based violence. And so I encourage you in my talk today that we will do our bit to bring about collective healing and embody the culture that Steve Biko referred to, one that we would be proud to pass on to our children. And so how do we go about this? First of all, we need to recognize our contribution to any dispute in any situation. We need to recognize that change starts with us and individually to take responsibility for it. Because as we heal ourselves, we heal our family. And by doing this, we break the generational cycles of trauma and learned behavior that has been either dysfunctional for us or for those around us. And so in our healing, we heal our children, and we know that healed families contribute to healed communities. And I'm hoping that we can start seeing how how we can build healed communities by starting with ourselves. To give a bit of context, most of us have our own wounds and our own unresolved traumas from childhood. And the reality is, as we grow up, we have an innate desire to be healed and to be whole. And so what we do unconsciously is we tend to be attracted to certain people that represent some kind of unjust or some hurt or some trauma that was done unto us when we were young. And in our adulthood, we attract these people and we try to resolve the unresolved stuff from our childhood. And we go into almost this play of trying to heal, but it's a very destructive and unhealthy way of trying to bring healing to yourself. And this kind of thing raises things like triggers. So you get triggered, and when you become defensive, instead of having conversations around issues or disputes, you become defensive because someone has triggered you. And we model this kind of dispute resolution to our children, how to resolve disputes and how to interact with others. We model this to our children, and our children grow up and we're told our children are bullies, very destructive in class and to others. And the truth is, we are modeling this behavior to our children. And so to give an example, a real life example, I'll be the first to confess that I was, or I am, a recovering road ranger. So when I started driving, and for many years, I used to be very angry behind the wheel. And I was hooting and screaming and swearing and locking taxis on the pullover lane. And I was just not the best person to be in a car with. And I remember one Saturday morning, I was with my daughter's friend. She must have been about 5 or 6 years older than I. And someone had blocked me in a parking lot. And because I was rushing to fetch my daughter from ballet, I got really angry. I was hooting and swearing. And I turned around and I saw this little girl with her eyes like, and she was so petrified. I took a step back and I was like, she's not used to this behavior. And I was showing her how to resolve an issue of being locked in a very disruptive way. And through honest conversations with Dion and my daughter, they would tell me that every time they sat in my car, they would feel unsafe and uncomfortable, and that the journey was just not very pleasant. And so it took these honest conversations. I had to accept that I had a problem. I had to take accountability for my actions, and I had to recognize my triggers and choose to change. And choose to change every time that I was triggered. And then we see other things like gossiping and speaking ill in front of others, and speaking ill of others in front of our children, abusing alcohol or substances and becoming violent in front of our kids, threatening we're going to teach someone a lesson, and we do this over the dinner table, and our kids are watching us. We're speaking ill of the other parent who's not present, the other parent who's not paying child maintenance in front of our children. And our children are developing an idea of who that other parent is. We also slam doors when we're angry, we walk up the room, we storm up in anger, and we're not being brave enough to have the hard conversations, to find common ground, and to respect each other when we find a dispute or something we don't agree with. or being silent or being silent when we see someone else being abused. We are all contributing to some form of gender-based violence, and it's going to start with all of us in this room, all of us online, and all of us in the greater community to change the narrative of how we fight gender-based violence. And so this is going to require us to be honest and to be brave with ourselves. We have to do the inner work and decide to take responsibility for our own healing and to recognize the triggers that spark animosity, offense onto others. And sometimes this shift happens as a result of an awakening. So my awakening as a road ranger was when my daughter and my husband and the little girl in my backseat had her eyes had gone like this. That was my awakening. And through that, I was able to make a conscious effort to change my behavior every time I found myself in that position. And so I encourage everyone here to recognize your triggers, to recognize when you want to respond in a very unhealthy way for any type of relationship, and to be able to be conscious of your response to that person in the relationship. And there's so many good therapies. I mean, the last dialogue we heard of like family therapy, mediation, psychotherapy. There's so many therapies out there that can help us begin our own inner work and help us become better persons within our family and our society. And so mediation is one of those tools that I have seen to be helpful in sparking that awakening and restoring relationships. And to remind parties why they are still in certain relationships. So I'm an advocate for mediating these kind of cases that can be mediated. But I also just want to stress out that not every case can be mediated due to the complexities, due to maybe I don't want to say the nature of the abuse, because abuse is abuse, but some cases cannot be mediated and they need professionals to kind of help them navigate out of that difficult mess. And I really want to say this with caution for all mediators, attorneys, and magistrates, that we need to, the onus is on us to recognize when there's a case we cannot mediate, and then refer the people to the relevant professionals that will help them. And so I think it brings us to the question, can mediation be a tool to help individuals and families build stronger and safer communities? And my answer is yes. I have mediated so many domestic cases in the domestic violence court. The results have been amazing. And you know what is so beautiful is when parties, and it's been a successful mediation, and it's been a very difficult mediation. Just to give an example, last week I was in a mediation for 3.5 hours. I had 2 attorneys sitting outside representing each party, and we had social workers from either side of the parties. And it was a really difficult mediation. But at the end of the mediation, it was successful. Both parties understood why they were there. They understood why they had to make the concessions they had to make for their child. And it was always in the best interest of the child. And when they walked out their door, they said thank you. They reached out and they wanted to thank me. And for me, that is so rewarding when you can see the process of mediation help resolve issues that cannot be resolved in a courtroom. Because the truth of the matter is, when we got there, the father was flying in from somewhere in South Africa, and when we got there, the magistrate said, well, we've only got 2 hours. We've got 1 hour to mediate, and we've got 1 hour for court proceedings. And I went and I read the file, and I was like, we can't do it in 1 hour. And I spoke to the magistrate, and I said, look, we've got social workers. It's a very complex case. We cannot do it in an hour. And she said, okay, fine, 2 hours. It took us 3.5 hours to really unpack the issues, to really make the concessions that were good for the child, and both of them could be comfortable with and be happy with in the end. And you also see the results when magistrates, at least in my report, I see more and more magistrates referring more and more matters for mediation. And the reasoning behind that is, if you've ever been in a domestic violence court, or even children's courts, I mean, I think many of you have, the queues are so long, it's just overcrowded, it's an ugly place to be. But what the magistrates have come to understand is that if we can unpack these issues and we can really help the parties understand where the conflict is, where the disputes are, it's a much gentler process for both parties when they understand them being in a courtroom, and the magistrates don't have the time to really do this. They're so often very fast to pass on protection orders, and what we come to find out, especially in co-parenting, that having a protection order is not always the best way to co-parent for many reasons. I think the most obvious one is when it's handover time, when you have to hand over the child to the other parent, and there's this animosity and acrimonious sort of vibes in the air. You're not saying anything to the other parent, but the children are picking up that energy. And what happens is they internalize this because they can't speak about it, and they begin to get anxious for the next time that I have to be dropped off at mom, or I have to go to dad. And there are even situations where I know there's like a little toddler of 2 years old. The drop-off is with somebody central and not mom or dad. And my heart really just broke because I was like, what are we doing to this little kid? This 2-year-old lived with mom and dad for quite a while, and well, you know, for maybe a year and a bit. And mom and dad have decided to split now. But what are we doing by allowing a child to be handed over to the other parent with someone neutral? There's something wrong with that picture. And I know that child, one of the things is that child bites its fingernails until its fingers bleed. And that's a cause for concern. So like I was saying, mediation is a form of restorative justice. And what I think magistrates or the court clerks don't tell the applicant or the respondents is that if a protection order is granted, it has a negative impact on the respondent's name in terms of applying for a job, wanting to apply for a visa overseas. And some of the matters that I've seen, that we've mediated are matters that I really, or let's say the magistrate wouldn't warrant a protection order. And we need to keep in mind that if we're putting a protection order against a father, because it's often the fathers, or one of the other parents, and they cannot get a job because there's a protection order against their name, and then they don't have money to, they don't earn a salary and they cannot maintain their child. So we need to be conscious of when we apply for protection, and there's a place for protection orders, don't get me wrong, there is a place for protection orders. I mean, this week I had a case, and I think this is where, as mediators, we need to be very aware of the things that are not being said in the room. And so I had a situation where it was a married couple, still married, they're heading for a divorce. They both had legal representatives. She's not working, the classic case, she had been home with the kid, and he's heading for a divorce. They separated. He is wanting to victimize her and to take away the child's right to see her. So he's already saying she's an unstable mom, but there's no grounds to stand on. He is saying the reason is she cannot maintain the child financially because she's not working. She's been a stay-at-home mom. Of course, she cannot support the child financially. And he said quite openly, as soon as we get divorced, I am going to get sole custody of the kid. And I said, there's really no grounds for that. And she couldn't speak in the room because she's obviously being abused and she's scared of her future. And so much was happening in the room. She wasn't speaking, he was speaking, and he wanted the protection order. And the more we spoke, there was abuse on her, physical abuse. And I had to kind of stop the mediation. I kind of broke all the rules of mediation, Laurie. I broke all the rules. I actually went to speak to the magistrate because I realized her life was in danger, and so was her future, and the fact that he wanted to alienate his child from the mother. I also had a conversation with the attorney. His attorney didn't go down well. But I think as mediators, we need to have those honest conversations and take a stand when we see something is not right. I'm just trying to catch up on my notes. And also what we found out with wanting a protection order in place is that some parents are so hard-headed, they want to prove I am right, I'll get you. And so they will go through with a protection order just for that sake, but they don't see the repercussions of the other person getting the protection order. I've also heard situations in a mediation where the one party will say, fine, go ahead with your protection order. I'm going to open an application against you and also get a protection order against you. So it's a retaliation game. And I think mediation is really there to say, let's not retaliate. Let's put the issues that are causing so much conflict and so much heartache and brokenness on the table. Let's see how we can maybe resolve those issues and begin that, youth parents that are co-parenting or relationships that are still subsist, like children who are still in the same class or workers who, work in the same work environment. Let's see how you can still continue to have that relationship in a respectful and a civil way for yourself and for those around you. And so in closing, I'd like to say that mediation is a part of restorative justice. And I have seen hardcore individuals threatening to leave the room in mediation because they're like, this is not for me. But it's amazing when they have that awakening. Those are the people that actually go out into society and begin to bring the peace, the love, and the restoration that I spoke about earlier. So I'd like to just give an example. For example, there was this one guy who had stabbed somebody, and he denied he had stabbed her. But there were other people, it was a big case, it was about 7 of us in the room, and those people confirmed that he did stab, and he refused. He said, no, I didn't stab. But through a process of talking and having honest conversations, he said, I did stab her. I'm sorry. And he looked at her in the eye and he said, I did stab and I'm really sorry about this. And when I asked, okay, now going forward, because they still live in the same kind of space, going forward, what are you going to do? When you feel triggered, when you feel like what happened in that moment, what are you going to do? And he said, I'm going to protect her from other people. And I was like, okay, but don't protect them by stabbing them. How are you going to protect them how are you going to protect in a different way? And he said, I'm going to have this kind of conversation with them. He was only 19 years old, but I think that's what I'm saying is mediation can bring about that awakening. It can be a tool to help us recognize our own triggers, like this young guy. And he said, I'm going to protect her in our neighborhood, in our neighborhood. And he would be that advocate for bringing about peace and change against gender-based violence. So on that note, I hope that I have encouraged all of us in this room to do our bit in bringing about collective healing for ourselves and for our families and for our communities. And thank you.
You look like twins when you say thank you for the presentation. The Law Commission paper 157, and I'll encourage you to read it. The SA Law Commission paper 157 on the Maintenance Amendment Act has a chapter. There's 39 pages that devoted to maintenance. So maintenance is going to become a reality in South Africa. And it's something that we should all listen and look at. The 105 people that are online, please get a copy of the SA Law Commission paper 157 on maintenance. Please read chapter 2, studying information that Professor Minky de Jong and her team contributed to the Law Commission paper on specifically what we should do as far as maintenance and mediations is concerned. Lonnie Guyvenstein sitting at the back contributed actually more to the whole paper than what the paper of the Law Commission did. So thank you, Lonnie, for all your contributions in there. every second word you read the notify these things, comments on it. So if you're gonna read it, I'm sorry, you're gonna actually read notify these things, comments on the Maintenance of Movement Act. So please do read it. If you don't get a copy of it, please email me and I will give you a copy. I will send a copy of the Law Commission's paper, or go to the Law Commission's website. You will find it. Else, if you want to read a copy, I'll send it to you tonight. There's also an ADR bill that is introduced in Parliament. That's the Alternative Dispute Resolution bill that is also being introduced in Parliament. That comment is closed now. But that's also a bill that will be discussed earlier or early in 2023 in Parliament. So please, if you want to have a copy of the ADR bill, if you want to have a copy of 157, the ADR bill is the 148. So if you want any of those copies, please let me know, and I will be able to send it to you, or just send drop us an email at info@childmaintenance.org and we will send it to you. I quickly have a video of Eugene that I want to play. It's a short video, and then after that I'll give an opportunity for questions if there are any questions, and then I will close off and just give you an idea of what we're planning for 2023. Pertaining to these type of discussions are what we should be engaging in. The Department of Education coming on board, saying what they are doing, and all the questionings that we're getting as far as contraceptives is concerned. Look at Section 134 of the Children's Act. Section 134 of the Children's Act says that children from the age of 12 who have access to contraceptives. If you compare it to the Offences Act, Section 15 and 16 of the Sexual Offences Act says that we're going to prosecute them for statutory rape or statutory sexual assault in a case where they do get involved in it from the age of 12, in terms of the amendment that kicked in on 19 August, the child justice legislation kicked in and said that if a child commits a Schedule 1 offence and is above the age of 12, then he can be arrested. Anyone younger, 11 or 10 years old, cannot be arrested as from 19 August. So all of those type of changes are happening. All of those things are going to be forming part of the community dialogue that we will be talking about from next year. The 3 GBV legislations, we will discuss that. The domestic violence legislation that will be promulgated next year, also promulgated, we're just waiting for the commencement date. The Department of Justice submitted the policy document in the regulations, and it is introduced in Parliament. So we're just waiting for the final bit as far as the electronic depository system and all of those things to be tendered and all of those things to be done properly. Then we're going to be dealing with that. But the GBV legislations, the Sexual Offences Amendment Act, we need to start speaking about it and have community dialogues about it. The Criminal Law Amendment Act 12 of 2021 that provides for audiovisual links for intermediaries, all of those things we need to start talking about that and have that discourse. Doing that discourse, we need to include the deaf community. We need to include the other communities that do not have their voice. And when we get people like mediators standing up for those people's voices. There's a provision in the Domestic Violence Act that says that those dignitaries or those people in those positions of power and authority, they need to act. There's a duty to report. So the only duty to report that the South African government recognizes is the attorney-client's confidentiality. Nothing else. If you go and tell the police, I will go and arrest the police, but in the case where that happens, where that information is shared in that. I understand mediations is a safe space for people to share that information. But if it is the abuse of a child or sexual abuse, then there will be a duty to report. So we need to have that discussion on how are we going to make mediation a safe space, but on the other hand, also make sure that the information and protection of the young and vulnerable is being achieved. There's a provision in the Sexual Offences Act dealing with vulnerability. Women under the age of 25 are deemed to be vulnerable and will be protected in a case where they are living at a tertiary institution or that they are living at a boarding institution or at a safe house or wherever they are, and they are being abused in any way in those places. Then it is also no offense, even though the person is over the age of 18 and
presumed to have consented to sexual intercourse, but because of the level of authority, those are the conversations that we will be having next year. The last page of your notes, you will see the program for next year. We start on the 28th of January. That's going to be our first talk, and hopefully we will be sorting out the interpreter, the sign language interpreter, and then there's a person who will then assist us in making sure one of the representatives of the SA will also address some of the challenges that the deaf people experience in order to access the justice system. And I'm one of them, that whenever a deaf person comes in, I just give them a piece of paper, this piece of paper, I write over there what you want to say. And it's not that easy, because they do not understand language the way we do. And it's not for them just giving them a piece of paper and they must write now what they're going to. And we are marginalizing that society on its own. And my eyes were opened a week ago, and that's why I'm fighting the cause for Tuboy and the rest of the deaf community. We will be taking it from there. We will open up now for questions, but let me quickly play this video of Eugene, and then I know there were some questions, and we will deal with those questions.
That is a traditional Indian greeting. Namaste, everybody in South Africa. That is a traditional Indian greeting. Hi there to all, just a short message from my side. You know what, you guys, as I said, I'm in India at this stage, enjoying my time here, enjoying the peace and quiet for a while after my trip to Delhi as well. I've met up with the most amazing people around here, apart from the chaos, the smells, the taste, everything. It is such a beautiful country. I've met up in Delhi, I've met up with a group called Action Aid India. They are doing very much upliftment work especially for women. And yes, as India is a very poor country, you know what, all the problems that we have in South Africa, it's basically the same that they are encountering here, especially when it comes to maintenance, especially when it comes to children. It is not unique to South Africa. It is all over the world. I've been in that fortunate position that I could assist them and help them with their 16 days campaign. I was feeding about 30,000 people, well, not on my own, but yeah, I was part of the group of people that fed 30,000 poor people, homeless people, as part of their 16-day campaign. So it is awesome what I've experienced on this side, and I will definitely come and share it with you guys on the next NPA meeting early next year. As for next year, yes, I think it's going to be a brilliant year. Loads of things happening, loads of ideas. I've not been sitting still this side. I've been formulating ideas like crazy, and yeah, you're in for a treat for next year. The NPA dialogues in a new format. There will be the lunchtime learning sessions on a certain day of the week, where we will discuss certain topics for during a lunchtime break, so that all people can log in. So we will do the talks for 40 minutes and then take questions for 20. On the cards are also a mediation, specifically pertaining to maintenance matters or maintenance mediation, a course that I will be presenting next year in collaboration with a couple of institutions offering mediation courses. So that's on the cards. And then there's also the maintenance summit that is on the cards for March next year. So all in all, good. My wish for all the moms in South Africa is a blessed Christmas, peace, and yeah, I hope that everything goes well. as 16 days on this side of the earth, and that side in South Africa is also coming to an end. Only my wishes for you guys to wish you well, and I'll see you guys soon.
I just wanted to play Eugene's one for you so that you can at least hear what he's busy doing in India. So Eugene has been part of the NPA dialogues right from the beginning, so that's why I thought it's important that I do honor him in the message that he did sing. If there are any questions, please, you can feel free to ask the questions. What we're also planning for next year is we're going to have something where we, during lunchtime, or when it is presumed lunchtime for everyone else, we'll have sessions on the maintenance legislation, on the domestic violence legislation, where we will host those type of lunchtime talks in order to somehow capacitate civil society and make sure that those type of things are coming up. There is plans to, and there are requests that we have a summit next year. It is in the beginning phase where we are planning to have a summit where we would like to somehow use that information in order to lobby Parliament as far as the maintenance amendment legislation is concerned. So hopefully, if we have a summit that can include civil society, that we can then get a collective that we can take to the next level when the deliberation starts in Parliament on the Maintenance Amendment Act. So yeah, that is what is on the cards for next year. There's a whole plan for every last Saturday of the month. We will have these community dialogues, but the community dialogues is not just going to be about maintenance, it's also going to include gender-based violence, it's also going to include domestic violence, sexual offences, and all of these things that we need to start talking about and make sure that people understand their rights. Because there's no way that we can separate domestic violence and, ladies getting a domestic violence order that they must stay apart from one another, but in the maintenance courts they're sitting next to one another. It just doesn't make sense. So in order, we must make it work, and we are going to make it work. A collective of us coming together, that's how we will make it work for all of us in order to understand this piece of legislation. Are there any questions or any online questions that we can deal with? You had your hand up earlier.
And it's not that it's a question. I just wanted to say we have legislation specifically focusing on IGR, integrated government relations. But the reality is that the government departments don't speak to each other. So that either deem it fit, no, it's not my interest. But the reality is, at that sessions, you pick up the issues, because I maintain that government officials need to pick up the social issues, the social economical issues when they deal with communities. And that's the platform where we, as government as a whole, need to unpack these things and see what policies needs to be implemented in order to ensure that the citizen get what the citizen is supposed to get according to the Constitution.
I wholeheartedly agree with you. That's why we are going to try and make this intersectoral, where we get the Department of Education here, we get the Department of Social Development here, the Department of Health, and all of us start speaking together and dealing with it in a collective framework, and not all of us haphazardly from different. But I thank you so much for your comment. Anneke, and then I'll get you something.
Okay. Now, if I can just comment on that.
Sure.
Besides being an activist, I've been an activist before I became an official.
Yeah.
But that is the harsh reality at a local level. I'm just going to take Mitchellspruit with a population of 1.2 to 1.7 million people. We have all the departments there. But if one department says, here, let's come together. There's an IGR, there's legislation. And the reality is that social development in the Western Cape are failing our communities. They're seriously failing our communities. And specifically our children. And that is, you see, if one person speaks out, then it's enemy number one. Enemy number one in
Can I ask, I don't understand the family forum, so maybe Annika or you can do a joint presentation on what the national family forums look like and why the Western Cape forum is not going forth, why is nothing happening? Because this is the type of talk that we need to do, and if we need to hold them accountable, then that's what we should do. Or I will ask Pearl to hold them accountable. Then we will deal with why isn't the Western Cape having a provincial family forum? And I've heard about it, and I don't know why it is not in any way existing. So maybe you, as a representative from the national forum, can maybe give us insight, Annika, and present something to us next, the 28th of January. I will make plates for you on, or there will be a slot for you. If we can speak about the forum, collaboration, then we can jointly have someone speak about what is happening on a national level and what is happening in the Western Cape as far as the family forum is concerned. Sandra?
I actually have a question for Natalie.
Yes.
So I've tried to mediate, I've requested to mediate, fathers refused, and it's been an ongoing thing for the last 4 years. We've tried to mediate, we've had different people, lawyers involved, and we've now done my maintenance application at Science Town. It's not quite in yet. But my question is, I've got an issue with the father. He continues to abuse me in many different ways, financially, sexual harassment, verbally, psychological. It's had a huge impact on me. And I'm about to take up this protection order. I've been struggling with doing the reasons that she said. But I cannot keep just that one more aggression to me. And then which mentioned on the group. It's just such an effect on my life. How can I not do this protection order now? Given that everything that, I can't get him to stop us getting asked him to. I'm trying to raise these issues. He won't communicate with me anymore. I believe that he has narcissistic tendencies, which has been, also expressed by my psychologist. Let's say that you can't mediate in cases when somebody's not a reasonable person, they've got actual personality disorders. So, what should I not do this protection order? He doesn't,
Can I also give lawyer an opportunity?
Let's hear Larry.
Yes. Thank you so much. Very, very relevant. There's a place for mediation, but some cases are not appropriate for mediation right from the beginning. Okay? About 10% of people walking on this earth suffer to some degree of personality disorders, etc., etc. Most of those cases are not appropriate for mediation, full stop. Unfortunately, members of the public are exposed to mediation and mediators who have not been trained in dealing with that. We have a full-day training just dealing with matters of domestic violence and when cases are not appropriate for mediation. One full-day training. And then some mediators are trained as mediators in 2 or 3 days. It's actually shocking. It should never ever happen. I'm willing to render a consulting service just to give you some guidance. You're welcome to contact me. We have free training in terms of domestic violence, in terms of maintenance, etc., etc. You're welcome to subscribe to those trainings. We are part of the Social Justice Foundation, which is an NPO, apart from the mediation work that we do. So those services are available free of charge. I've been in law dealing with disputes for 42 years. The first 25 years on a formal basis with the Justice Department, also working as a magistrate, and for the last 16 years at least as a mediator. Unfortunately, there's a problem out there. Some magistrates, some prosecutors do not understand what mediation is about. Mediation is a wonderful tool, but certain cases are not appropriate, full stop. It must go to court, and it must go all the way. And the perpetrators must be punished. You cannot mediate those cases, full stop.
You cannot see the abuse, you cannot see them doing anything wrong. You know, it's just, yeah. And he thinks it's okay, just over and over again, please don't do this, please don't do this, please don't do this.
Yep.
You know, I've given 5 years of saying it's not okay now, you know, and
Yeah. So you're welcome to my contact. We will guide you, but it seems to me those kind of cases cannot be mediated, but we can give you some guidance. And we can give you some training, which is free of charge.
I wanted to check the mediation procedure, just how much other things I should on immediate future.
Yeah, now I'm not saying you must be trained as a mediator at all. This is not what I'm saying. But there's free training that, you know, mediators can also make use of. Yeah, thank you.
Thank you, Laurie. Are there any other questions? Yes, sir. Do you want to come over here so that the online viewers can also hear? Sorry, I know please, so that everyone, these are 105 people online that also need to hear your message. Please, sir.
Based on the mediation, I think it's such a brilliant thing. What we're trying to do within our schools as well is equip our learners with creative and constructive approaches to conflict, as well as mediation skills, because it's that powerful tool of being able to communicate with each other in the correct way at the correct time. And it's not necessarily that mediation is always that the event is right for mediation at the time. But so in that way, our learners just learn this incredible skill of being able to communicate. So I think it's brilliant, and we would love to partner with you going forward and with all the mediators in the room, because I think that's just something that we need to get to a point where we're able to have those honest conversations. Then just to rewind a bit back to previous comments that was made, but within the education department, unfortunately, we need to, when it comes to the consensual age for children to consent to sex, unfortunately, we need to uphold the Constitution. So yes, government bodies and everybody has the role to play. However, we need to ensure that whatever we do at our schools is in line with our Constitution. In that saying that where it is that we need to lobby is on a policy level and not perhaps on the door of the education department. And that is in no way trying to shift the responsibility thereof. But in our cases is what we are trying to do through the curriculum and through the extramural programs that we have with our learners is trying to develop or trying to give them the knowledge in order to make informed decisions. And for us to be able to fight this, it takes a whole society approach to be able to educate our parents, our learners, and just our neighbors within our community to be able to guide our learners, to be able to tell our children what it is that they should do. Government also has a role to play, like you said. All our government departments has a role to play to come together with the community. But I want to stress this, and this is something personal to me, is that the answer doesn't lie within government. It's or we've been looking back at government asking, so what is government going to do? Unfortunately, as a government official myself, I don't understand the context of what is going on in your community, and you want me to bring a solution. And it's about time that us as community members identify what is the issues and the challenges that we face in our community and tell government that this is how the solution should look like and how can we come to then try and effectively resolve the problems that we have. Thank you.
Thank you so much for your comments. Thank you very much, ladies and gentlemen, for your constructive input and making a constructive impact within society. And I think together, we should all, you do, I do, we do, together we can all make a difference to the constructive impact. And yes, you're right, it is not government's job to change our families. The values and ethics starts from within, from us, then it is for government to implement. Government is just the body, basically, to try and hold the society together. I still do have a problem with the age of consensual sex at 12 years old. That doesn't take away the fact that we as families suffer because government has made a decision like that to take away the innocence of young children. So today, I think now at the end of the year for the NPA, with all the final or the presentations that's been held, I would like to thank you on behalf of Advocate Renkes and the NPA, Mrs. Renkes, and all the speakers that spoke here today, to say thank you very much for your constructive impact. Thank you for participating. Thank you for making a change. And we look forward to seeing you for the following year and hope 2023 will bring a lot of changes. It's already been implemented, a lot of communication, and as long as we can communicate as a society, and we're all willing to add value and change, we can make a difference. Thank you very much.
We're leaving now.
Where do you think?
I stay in Plumstead, but I can go that way around. It's fine. It's so nice to have you here. So I'd love to do that too. Are you part of the deaf community in? Oh, you saw us there. Okay. Wonderful. Okay, wonderful. Sorry, there's so many people last week. I couldn't see everybody. But lovely to have you here.
She's a legend.
Everybody knows it.
Yeah. It's fine. It's fine.
Thank you so much for everything. Are you leaving now?
Yes.
I'm just switching off.